31st of March.
এইখিনি অহা নাই জানো জানো আমাৰ briefখিনি আহিছে জানো no for urgent listing
Yes, my lord. Yes, my lord. I'm for urgent listing.
so when do you want
My lord, 29th, my lord, of this month. Because my lord, this month is already here. My lord, three petitions, my
Okay.
lord.
item number
19 of court number 18.
okay 3 oh this will not like to pass any orders
And I know, but yeah.
no, there will be difficulty it's already an indication you try before you make a application before the registry okay
Lordship, item number 29, ma'am.
of court number
Of this court.
of this court
My lord, in the order, my lord, when notice was issued, my lord, the writ petition number with which it was supposed to take, my lord, it was wrongly mentioned, my lord. So let it be posted, the adjourn for that end may be posted with 5896 of 25, my lord.
item number 19
29, my lord.
29 what is it
Supplementary,
supplementary
my lord. Last item.
yes office there is an office note
My lord, in the order, my lord, there is a typographical mistake, my lord. Instead of mentioning 5896 of 25, it was mentioned as 5896 of 2020, my lord.
okay let the matter reach will
Lordship. Of like,
yes
That
Mr.
is your-
Bhattaji.
I beg to mention item number 17 of this code, my lord.
17
Yes, my lord.
Okay.
This may come after 10 days, my lord, due to shortage of some documents relevant to, I could not file my affidavit in time, my lord. Otherwise, affidavit has been prepared, my lord. Recently, I have got this
Okay,
documents, my
on,
lord.
I have informed the other side.
Yes.
I am for other side. Can you fix a date, my?
We'll-
10 days, any date fixed.
On
my
the
lord.
request of Sri P.S. Bhattacharya, learned standing, learned CGC,
No, my lord, it's a municipality board. Respondent number 2 and 3, I am appearing for.
respondent was, learned counsel for respondent was 2 and 3. Matter is adjourned by 10 days to enable him to file the affidavit in
My
opposition.
lord, my lord.
Para, list on 10 days, we'll say, we'll list on 6th of May, is it okay?
Yeah.
6th May. Is there any interim order, Mr.?
No.
No, my lord.
6th May, yes, yes.
Lordship, I beg to mention WBC AF7625 on listing 30 April.
What is the stage?
Just admission.
What is the urgency?
Urgency, Lordship, it is a matter of land dispute matter between brother and sisters.
So what is the urgency?
It is last listed on 5 months.
That is not an urgency. Sorry, out of turn listing there has to be an urgency. Sorry. Yes.
May I please, your lordship? My lord, with the consent of the other side, I beg to mention item number 5, 11, my lord.
11,
My
yes.
lord, I need to file affidavit in reply, my lord. So, my lord, 4 weeks time.
The FCI has filed
Yes, ma'am.
affidavit.
Yes,
Okay.
they
Have
have
you
filed.
informed the other side?
Other side already consent, my lord. From
Madam, you are for FCI?
Yeah.
Okay. On a request made by Sri
T Sheikh, my.
T. Sheikh,
Yes, ma'am.
learned counsel for the petitioner, matter is adjourned by 3 weeks
Right.
to enable filing of rejoinder affidavit. Yes.
Highly obliged.
Is there any interim order?
No, my lord.
With regard to item number 22,
Yes.
I have this humble prayer. My affidavit is not ready. Let's
You need time to file affidavit?
yes.
Okay.
2 weeks time may be granted. Your Lordship.
Okay.
I've
You,
taken consent from
inform the other side.
The date, Lordship. 21st.
You're for the petitioner? Okay.
I am for respondent numbers 5 to 12.
Okay. On a request made by Sri A. M. Datta, learned counsel for respondent number 5 to 12, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Madam, your name?
B.S. Ojha.
Ms. B.S. Ojha, learned counsel, is present for the petitioner. Para? List on
20th or 21st?
21st.
21st. Is it okay? 21st. List on 21/5. By which time the affidavit is required to be filed? Yes. Is there any interim order?
8/12/2025.
Interim order is there. Interim order passed earlier to continue till the next date of listing.
Master.
Yes.
May I place before lordship, item number 3 of court number 18, my lord.
Yes.
Maybe.
Part heard matter.
Part heard matter. I may be allowed to withdraw this petition as we challenge the appellate order, my lord, rest issue.
You want to withdraw this?
Yes, my lord. We have to challenge the appellate order.
আছে নেকি আমাৰ হেৰিটো ফাইলবিলাক আছে but it's only for listing urgent listing কালি বহিব নে কাইলে File to annual order to pass through your point. You coordinate with our court master. If the file comes, we can pass orders. Otherwise, it will come up for
Yes.
consideration tomorrow or day after, or Monday.
May I please, Your
Please
Lordship?
coordinate. Yes.
Yes.
My lord, I beg to mention item 14 on behalf of senior advocate BC Das, who is sick.
Okay.
Detailed accommodation is required. Item
Okay.
14.
Good. Okay.
I have informed
Okay.
Mr. Handicap.
Okay. On a request made on behalf of Sri BC Das, Learned Senior Counsel for the petitioner, matter is adjourned to be listed after 2 weeks.
Yes.
We give a date, Mr. Biswas,
Any date, my lord.
list on,
Second part of the name, my lord.
we'll have it on 11th of May.
13th April.
13, not 13 April, 11 May.
All right.
11 May? 11/5.
I'm sorry. Say April.
May it please the lordship. Item number 16, my lord. If,
Item 16.
my lord, if I can guarantee.
You had made a mention yesterday.
Yes, my lord. I
Yes,
made a-
what is it?
My lord, I have circulated a mention memo, my lord.
We have seen it. Why do you want time?
My lord, I have little difficulty today, my lord. Any date when a second.
Affidavits filed.
Affidavit, my lord, the GST, he has said that they will not file an affidavit, my lord.
Who's for the GST, Mr.
Yep.
Meedhi?
They're
Is he there?
proceeding-
Madam, you're for item 16. Have you filed your affidavit? Will you file your affidavit?
Now, I have not obtained the instruction regarding whether we are filing or not.
No, this is a matter of 2023. You have to say whether you're going to file affidavit. If not filed, if you're not filing, then you can have it for, why do you want time?
My lord, I
Some
have-
difficulty today.
Today, my lord, I.
Okay, we'll have it on Monday. Let's see.
On second, my lord, can it be on second, my lord?
Second.
Second of
Okay,
May, my
wait,
lord.
okay. On a request made by Sri ABD,
ABD.
learned counsel for the petitioner, matter is adjourned to be listed
On
on-
second of May, my lord.
to 2nd of May is a Saturday,
My lord, it's working. If not inconvenient, my lord, only.
not 2nd of May. We'll have it on 6th of May.
Deeply obliged, my lord.
Why should we fix a matter on Saturday?
My lord. My lord. Obliged, my lord.
May I please, Your Lord?
And invite trouble.
My lord.
Yes.
My Lord, court number 18, item number 34, Your Lordship.
Court number 18,
My Lord, item number 34,
3-4.
my, in orders column.
34. What do you want, madam?
IA is for correction, Your Lordship. Instead of higher education, we have wrongly written, instead of secondary education, we have wrongly written as higher education, Your Lordship.
Okay.
And it's reading for secondary.
When do you want?
Monday, my God.
Monday, okay. Item number 34, huh? On the request of Miss Asajia, learned counsel for the applicant, list this matter on Monday. Date to deliver. Miss P. Das, learned standing counsel, secondary education is present. Date to deliver. Monday. Monday ki ban hoga? 20? Okay. 27. Yes.
Lordship, I beg to mention an item for listing, Lordship, it's a writ petition against the election petition that was cancelled.
Press matter.
Fresh matter.
Press matter, we can have it tomorrow.
Tomorrow.
Or Monday, whenever you want.
Tomorrow if possible, Lordship.
When did you file?
Yesterday, Your Lordship.
Okay, tomorrow is possible.
I'm deeply up.
Yes.
May I please, Lordship, I would like to mention item number 25.
25.
25.
Yes.
On behalf of M. He's suffering from some hair problem.
25.
25. With
On
the
behalf of,
M.
but, Mr. This is a 16 matter.
M.
16 matter.
Yes, Lordship. I can-
2016 matter difficult.
Next week, Lordship.
No, let it reach. We'll accommodate, but not like the 16 matter. It's not for routine adjournment. What is the problem?
He had a ear operation, so he had to go to checkup.
Okay, then
Any day next week, Lordship.
have you informed the other
I
side?
have informed the
Okay.
other side.
A prayer for adjournment has been made on behalf of Sri M. Moore,
M.
learned counsel for the petitioner. First of, however, considering that this matter is pending since the year 2016, while the prayer for adjournment is rejected, a slight accommodation is granted, directing listing of this matter on, yes, tell us the date of your convenience. Today is 23rd. We'll have it on 29th. Okay, 29th, he'll be able to come?
Lordship.
29th.
Hello.
29-4.
May I
Okay.
please, Lordship? I pay for listing for your Lordship.
Bench 5 matter.
Yes, sir.
May I please, your lordship. Lordship, I beg to mention listing of an item for bench to matter pertaining to court number 18 on Monday, lordship.
Motion.
No. And IA, it was last listed on February 9th, lordship.
IA for,
IA for amendment, lordship.
okay.
May I please, your lordship? Lordship, I beg to mention item number 6 and 7, your lordship. As my senior could not come due to some medical issues, your lordship.
Who is your senior?
In 6, item number 6, I am on behalf of B. Bhuya, and on 7, I am from PK Sharma. Item number 6, I am on behalf of B. Bhuya,
And 7?
and 7, PK Sharma, your lordship.
Okay. When do you want? These are 20 matters. Why are you mentioning? Okay. Monday,
Otherwise, infructuous.
infructuous.
Monday, my senior is not there.
Okay, Monday. On a request made on behalf of the petitioner, comma, petitioners will cover. Matters are adjourned to be listed on Monday next. Date diba. That I order diba. Petitioners will cover at us. Okay, Monday. 27. Ms. Sri J. Hendik, State Council, and as well as Sri S. Dr. and Standing Council PNRD are present.
But this lordship's affidavit for listing a admission matter, my lord, last posted on 11/12/2024, my lord. Thereafter,
Urgency.
urgency, my lord, matter relating to, my lord, allotment and settlement of land, my lord. Settlement order already passed, my lord.
Sorry. You approved the registry. Sorry. Yes, Mr. Bhattacharya.
And another two matter, my lord. One is regarding, my lord, ICT.
See, if it are motion matters, we'll allow it.
Admission matter.
If it is not in motion, then there has to be an extreme urgency for a mention memo.
My lord.
If it's not urgent, please do not mention. Yes,
Item number 28,
28.
it is already fixed on 12th of May. Only thing, my lord, on last occasion, the interim order was not extended.
Okay.
So you can just interim may be extended and.
28 supplement list.
Supplement.
Okay. Have you informed the other side? Heard Sri D.K. Bhattacharya, learned counsel for the petitioner. Full stop. Also heard
A. Kakoti.
for
8, 9, 10, 11.
you are the private respondents. What about
respondents.
cooperation department? Is anybody there?
SK Talukdar, he is appearing.
Is he there?
He's there, but he appears in the matter, but
Today is he present in the court?
not seen him.
On
the last occasion.
Also heard 3A Kakoti, learned counsel for respondent numbers 10, 11, 17, 19, and 20. Full stop. Mr. Hendik would be there probably. Where Talukdar, if just
Yes,
see if
we will-
Mr. Talukdar is there, we'll try to record his name if he's there. Talukdar to likhe rahi hai. This matter has been listed by a mention memo filed yesterday on the ground that while the date was fixed on 12th May 2026, the interim order, the prayer for extension of the interim order was inadvertently left out. Full stop para. Considering the above, while the matter is to be listed on the slated day, that is 12/5/2026, the interim order passed earlier would stand extended till the next day of listing.
Obliged.
Slated SLATED. Yes.
I didn't want to look over this.
May I please, Your Lordship? Well, this matter is relating to allotment of land. The present two petitioners, Lordship, they are poor and river eroded people. Their residents were eroded in the year 2005. Thereafter, Lordship, they become landless. And
River erosion
yes,
affected
2005.
two petitioners,
My lord.
2005.
Thereafter, Lordship, they were settled here and there, and finally, from 2006, they settled in a plot of government land.
Settled.
Yeah,
Settled.
yes.
Order was passed.
That the authority has a Lordship, although there is no written document, but they were settled in a plot of government, and subsequently, land has been allotted.
When?
allotted in the year 2000 lordship 15, that is 23/11/2015.
23/11/2015.
2015.
Allotted, that
Ye-
part of land has been allotted.
Yes. Lordship, page 16, relevant page 21.
Page 16.
16. Relevant is page 21.
How many petition? Two petitioners.
Petitioner, that is.
Thereafter,
My lord, after 2.5 months, their allotment has been cancelled by holding another SDLSC meeting. Against that, this representative petition is filed.
okay, which is the order by which it has been cancelled? Date
Yes.
of the order?
That is 6/2/2016 SDLSC meeting. Page 22,
Allotment cancelled.
cancelled. And that same land has been allotted in favor of the private respondent number 6. That is the
What is
private.
the pay, which page 6/2/2026?
Page 22.
2016, page
Page 22.
22. And this land has been allotted to the
Private
private
respondent
respondent.
number 6, that is the private school.
R6 is a school.
Yes.
Okay.
My lord, that is without providing any opportunity of hearing that that has been admitted by the respondent in their affidavit, lordship.
No opportunity furnished.
No.
Thereafter,
Thereafter, lordship, this assailing that SDLSC meeting, this present repetition is
is
filed.
there any stay order?
Yes.
Stay order is there.
Stay.
Stay order is there.
Yes.
You are occupying the land.
Yes. Still, I have a residence, lordship, constructed house, and we are residing since 2006.
Okay, what do you say, Mr. Hendrik? From 2016 to 2026, they are residing. Are you interested? Respondent number 6, Mr. Hussain,
I am the respondent number 6.
are you interested in contesting this?
My lord,
Why your 10 years have passed?
my lord, when this petition filed, my lord, thereafter filed the affidavit in opposition. In that opposition, the land is possession in favor of the, my lord, respondent number 6. And my lord, when the approved in favor of the, my lord, the school, that school pays, my lord, 22, and my lord, column
Now,
number
Mr.
3.
Hussain, we are asking you, are you really interested in contesting this? 10 years have passed.
I
The,
am, my lord,
the persons have changed for the school.
My school, my lord, my school already existed 2005. And my lord,
But where are you functioning from presently?
present school, my lord, Rainbow English Medium School
No,
already.
from where are you functioning?
My lord,
Where is your building?
building, my lord, is my land, my lord, and the, my lord, allotted land is, my lord, adjacent land.
Adjacent land.
Adjacent land.
You are functioning.
I am also functioning.
So why do you want this land? They have not been given any opportunity. On the ground of principles of natural justice, a case of interference is made out.
My lord, as per the input order, my learned friend, my lord, is page 22, column 3. And
Page 22.
Page 22, column number 3. My lord, column number 3, my lord.
Yes.
This, my lord, the individual land allotted proposal were approved in last SDLAC meeting of South Salmara Mankesoft Habsuban held on so and so under Mankesoft Circle by resolution number. My resolution number is 48.
Yes.
Are cancelled for no possession. That time, my lord, when cancel no possession of the petitioner, no landless certificate, thought of other relevant documents, etc. over the plot of land at present, as per the report of the circle officer and ASO, Bankeswar Revenue Circle, file letter number so and so, my lord. Thereafter, my lord, the 5, my lord, column number 5, Rainbow School was approved. That time, my lord, the petitioner no documents, no landless, no documents submitted by the authority, and my lord, the record is, my lord, received, my lord. That report, my lord, no landless certificate already submitted at that time, my lord. When, my lord, this cancel of this, my lord, petitioner land and approve me, my lord. And I am
Mr. Hussain,
my school, my
Mr.
lord.
Hussain, before this decision was taken, was any opportunity granted to the petitioners?
My lord, that.
That you will not be able to say,
My
that the
lord,
government will be
report
able to
says-
say.
Report, my lord.
Mr.
Yes.
It doesn't appear that there any hearing was granted.
No. That was again, my lord, in the meeting. That proposal have to be set to the, my lord, comment first. After getting one approval, my lord, that then can be, my lord, the allotment can be, my lord, can be, my lord, made. It was, my lord, only the next day, my lord, it was, my lord, cancelled. The proposal was not sent. They have to send a proposal, my lord, after the, my lord, that SLC meeting.
See, there would be two aspects. Now, a particular land, there is an approval by the SLADC to allot a particular plot of land. Now here, if the petitioners were not in possession, matter would have been different. Now they are in possession. Now, by this approval, you may be correct that no indefeasible right has vested upon them, has accrued to them, until the government passes an order of allotment. But the fact that they are in possession and you cancel this approval without giving them an opportunity, you can give them an opportunity.
My lord, just I am reading one paragraph of their affidavit by the deputy commissioner. With regard to the statement made in paragraph 5 of the writ petition, the deponent admitted the fact that notice was not issued. However, field inquiry was conducted and a report was submitted on the present status of the land in question. My lord, in fact, their own affidavit, lordship, they have stated another paragraph.
Paragraph, which paragraph?
Paragraph, lordship,
Page?
page, lordship, 2.
No, running page.
Running, lordship, it will be a running page, it will be 25. Affidavit filed by the respondent number 2 on 24/8/2016. Paragraph 4 and paragraph 4, 5, 6 and 7. Short paragraph, lordship.
Where there is an admission that no notice was issued?
That is paragraph, lordship, 7.
Okay.
My lord, one latest affidavit filed by the respondent, that is the respondent number 2 on 18/3/2026. Paragraph 2, 4 and 5. Your lordship may kindly see.
Page?
That is a running page, lordship, 52,
5-2.
lordship.
Affidavit by?
52, paragraph 2.
By affidavit by?
Filed by the respondent number 2. Page 52.
Sandeep Kumar Sarkar,
Lordship.
R5. Is it R5?
R5.
By the assistant commissioner.
Yes, assistant.
R5. R5.
Lordship.
Okay, that is page 62, new page.
Page 52.
No, 62. That is the
Yes.
new page. 62, correct your page. Okay, affidavit by R5. He is the assistant commissioner. It's filed on 19th March.
19 March 2026.
Yeah, what is there?
Yes. Paragraph 2, your lordship may kindly see.
Yes.
That this court by an order dated 28/1/2026 directed to place before this court the contemporaneous records basic on which the circle officer Mankasar Revenue Circle had issued certificate both dated so and so to the petitioner, certifying them to be affected by the severe river bank erosion. It is also stated in the order that in the said certificate the year in which the land of the petitioner eroded by the river Brahmaputra is not mentioned.
Hmm.
It is only mentioned that the certificates were issued on the basis of report submitted by the field officer, DN and so and concerned Pradhan, and directed to place before the court the report on which the certificate were issued. On 23/2/2026, the Honorable Court grants time to bring on record the certificate issued by the revenue staff on the basis of which the certificate dated so and so were issued. The deponent respectively stated that river erosion certificate were issued on 22/1/2026 on the basis of the report of submitted by so and so Mankasa revenue, that the LRA staff in his report stated that the petitioner are daughter-in-law of the Pattadar whose land had been eroded in the year 2005, and petitioner are not Pattadar of the eroded land. The field officer of the Mankasa Revenue Circle in his report dated so and so
Yes, please read.
stated that petitioner family has been affected by erosion caused by the river Brahmaputra, due to which they were compelled to shift from their original village and are presently residing in the revenue village of Bhimapara. So the certificate which I have lordship subsequently annexed to my additional affidavit, that has been supported that the petitioners are the river eroded people. And they are presently, they are occupying the land lordship, and their houses were eroded in the year 2005.
No, this aspect can be verified. We are mainly on the part of not granting an opportunity.
Yes.
And there were certain reasons cited for cancellation. Let them verify the reasons. They said that you are not possessing those documents. You produce those documents.
Yeah.
Okay.
My lord, in fact, the first allotment was made after causing verification. That report also I
No,
have.
that definitely appears to have been done, but the subsequent impugned order, impugned resolution, which is the subject matter of challenge,
Yes.
says that you have not given certain
Yes,
documents.
absolutely.
And that appears to have been done without giving you an opportunity. Okay.
My lord, this certificate are dated 2026. And when this, my lord, this cancelled by the petitioner land in.
Mr. Hussain, we are not expressing any opinion
My lord.
on the validity of the
My lord.
documents, genuinity of
My
the
lord.
document.
My
It will be examined by the appropriate authority. That will not cause any prejudice to either of the parties.
My lord.
Okay. Okay. Please have your seat. The present application under Article 226 of the Constitution of India has been instituted by two petitioners with the following prayer. Okay, prayer to court kore jabo. As per the facts projected, the petitioners are river eroded, are river were affected by river erosion, and they were occupying government land measuring 15 lechas each, covered by DAG number 414/64 PT in the revenue village Himapara under Mankachar Revenue Circle. Full stop. It is contended that such possession was from the year 2006. Full stop. In the year 2015, the Subdivisional Land Advisory Committee, in its meeting dated 23/11/2015, had approved the allotment of the land in favor of the petitioners. Full stop. However, while the impugned resolution of the committee dated 6/2/2016, the aforesaid allotment has been cancelled. Full stop. Cancelled, and full stop, and the land has been allotted to the respondent number 6 school. Full stop. It is this action which is the subject matter of challenge in the present writ petition. Para. I have heard Sri M. Khan, learned counsel for the petitioners. I have also heard Sri J. Hendik, learned state counsel. Revenue is anybody? Sri A. Bhattacharjee, learned standing counsel revenue, and Sri Jed Hussain, learned counsel for the respondent number 6. Para. Sri Khan, the learned counsel for the petitioners, has submitted that the decision by the SDLAC in the meeting held on 23/11/2015 had taken into consideration all the relevant factors, and the approval for allotment was made in favor of the petitioners, who were already in possession since more than a decade. Full stop. But he has drawn the attention of this court to the resolution dated 23/11/2015, wherein the relevant aspect pertaining to the petitioners finds place against real number 48, correct? 48. He has submitted that by such such decision, comma, a right vests upon the petitioner, a right had vested upon the petitioners, and by the impugned resolution dated 6/2/2016, the said right has been infringed. Full stop. He has submitted that apart from the impugned decision being irrational and arbitrary, comma, the same is also in gross violation of the principles of natural justice, as no opportunity of any kind was afforded to the petitioners before such cancellation. Full stop. The learned counsel has informed this court that while this writ petition was moved, there was a stay order which is holding the field. Full stop. Tara? Sri Khan, the learned counsel, has also submitted that the aspect that no opportunity was granted has been admitted by the respondent number 2 in the affidavit filed on 26/8/2016. Full stop. He has also drawn the attention of this court to a recent affidavit filed by the respondent number 5 on 19/3/2026, wherein the verification of the certificate pertaining to river erosion has been dealt with. Para. Three, Hendik, the learned state council, has, on the other hand, submitted that the resolution dated 23/11/2015 would not vest any indefeasible right upon the petitioners, as such resolution would be required to be approved by the government and pass allotment order. Full stop.
Number 3. Last line, all the methods related to the individual lands, the allotment proposal will be taken up in the next SLDC meeting.
He has also highlighted that the resolution itself made it clear that where page?
Page 22, number 3, last line.
22 is the impugned 22 is the impugned resolution. No, not that. He has also submitted that in the impugned resolution dated 6/2/2016, there is an observation that matters relating to individual land allotment would be taken up in the next meeting. Full stop. The learned state council has submitted that since no right had accrued to the petitioners, comma, the impugned resolution dated 6/2/2016 cannot be faulted with. Full stop. He has also submitted that the land is supposed to be allotted to the respondent number 6, which is an educational institution. Full stop. The learned state council has, however, fairly considered that from the materials on record, it does not appear that any opportunity was granted to the petitioners before the impugned resolution was adopted. Full stop. Para. Sri Hussain, the learned Sri Bhattacharji, the learned Standing Council, Revenue Department has endorsed the submission of the learned State Council. Full stop para. 3. Same, the learned council for the response number 6 has submitted that the impugned resolution has cited reasons for cancellation, and therefore the same is not required to be, the same does not warrant any interference. Full stop. Yes, by drawing the attention of this court to the impugned resolution dated 6/2/2016, comma, the learned counsel for the response number 6 has submitted that the same clearly mentions that there was no possession oblique, no landless oblique, short of other related documents over the plot of land, which includes the plot against serial number 48 pertaining to the land allotted to the petitioners. Full stop. Para. The diverse submissions have been duly considered. Para. The present challenge has been structured on the grounds that the same is arbitrary and unreasonable, and also on the ground of violation of the principles of natural justice. Full stop. The impugned resolution dated 6/2/2016 would reveal that certain reasons have been cited regarding lack of documents. Full stop. The said reasons, however, have been stoutly disputed by the learned counsel for the petitioners who have submitted that all relevant documents were present which have been ignored. Full stop. At the same time, comma, the other ground of challenge is on the aspect of violation of the principles of natural justice. Full stop. In this regard, comma, in this regard, comma, it would be pertinent to note the stand of the Deputy Commissioner, that's response number 2, in the affidavit filed on 26/8/2016, comma, the relevant part of which are extracted herein below. Page 24 onwards, sub para 4 to 7, quote code 4, 5, 6, 7. Para. As pointed out by the learned counsel for the petitioner, comma, the response number 5 has also filed an affidavit recently on 19/3/2016, from which it appears that there were certain documents pertaining as documents public certificate of being landless of the petitioner. Para. From the materials on record, including the affidavits mentioned above, comma, it is not in dispute that before adopting the impugned resolution dated 6/2/2016, comma, no opportunity was granted to the petitioners. Full stop. While Sri Hendik, the learned State Council, may be correct in contending that no indefeasible right has accrued upon the petitioners, comma, taking into consideration that the petitioners are admittedly in possession of the land since the year 2006, comma, principles of natural justice would require that an opportunity, public notice, be afforded to the petitioners so that they could place before the authority all the relevant documents and materials, which admittedly has not been done. Full stop. Para. This court has also noted that while the writ petition was moved on 2/3/2016, comma, an interim order was passed to which was until further orders. Full stop. The learned counsel, there is no dispute in the bar that that on the strength of the interim order, the petitioners are possessing the land in question. Full stop. Para. In view of the above, comma, this court is of the view that the impugned resolution dated 6/2/2016 is unsustainable in law and accordingly interfered with. Full stop. Para. The interference, it is however made clear that the interference is primarily on the ground of principles of natural justice, violation of principles of natural justice, and the authorities would be at liberty to issue appropriate notice to the petitioners if any verification exercise is required. Full stop. Writ petition accordingly stands allowed in the manner indicated above.
Deeply obliged.
Asini ko, no? Why do you want to withdraw?
My lord, we want to file a case with liberty, challenging appellate order, my lord. Already we have done appeal before the concerned unit, but till date, no any findings returned to us, and but definitely we have knowledge from the opposition side affidavit, the rejection has been made.
Okay.
And for this reason, we want to.
What is your name?
My lord, my name is SJB Aklas Advocate on behalf of Anwar Hussain in this CRPF dismissal.
You're as
Z.
ZB Aklas, heard 3 as ZB Aklas Learned Counsel for the petitioner. Full stop. The challenge in this writ petition was an order of termination of service. And the challenge in this writ petition instituted in the year 2018 was an order of termination of service. Full stop. It was also contended that a departmental appeal was preferred, which was not considered. Full stop. The learned counsel has, however, informed this court that from the affidavits exchanged, it has been learned that the appeal has been dismissed. Full stop. The learned counsel accordingly submits that he may be allowed to withdraw this writ petition and with a liberty to challenge, to make a consolidated challenge, including the order passed by the appellate authority. Full stop. Anyone from the Union of India? Union of India? CGC? Any CGC? SK Medhi was there. Whether also holds through SK Medhi, learned CGC. Para? Considering the above, comma, the writ petition is dismissed on withdrawal with liberty as paid for.
Item 2.
Yes, Mr. Sharma.
Yes.
Old case 2018.
Yes, Lordship. May I please, Lordship? The petitioners are originally from missing community. So the petitioner number 1, he adopted the Christian faith for which he was excommunicated by the community in the year 1994.
Petitioner number 1 excommunicated.
Yes. And the petitioner, other petitioners, the rest of the petitioners are family members of the petitioner number 1.
How many petitioners are there?
Petition, 8 numbers of petitioners.
Eight.
Eight.
2 to 7 are the family members.
Family members of petitioner number 1. So owing to said reason, in the year 1994, he had to leave his native place, and one Mr.
You left the place.
My place, Lords. So one Moniram Dole,
Yes.
he had allowed the petitioner to stay over a land measuring two bighas.
Where?
Covered by in the year 1994.
Where?
Village, Lordship, Lagasung Nepali, under Bordoloni Mauza, Thamazi district.
In the same district.
Yes, same district.
Also, who allowed you?
Moniram Dole.
He's a respondent.
No, Lordship.
Achha.
Cousin brother of the petitioner, number 1.
He allowed you to reside.
Reside in a plot of land measuring 2 bighas, covered under Dag number 4 of village Lagasung Nepali under Bordoloni Mauza.
Okay.
So accordingly, since 1994, the petitioner and his family members, that is the rest of the petitioners, had been possessing over the land, raising their residential houses. What happened in the year, Lordship? In the year 1998, it came to the knowledge of the petitioners that the government authority, that is the respondent number 2, had allotted annual patta in the name of the respondent number 5. Respondent number 5 is
Annual patta in respect of which land? This 2 bigha land?
Yes.
Which was allowed by Moniram to you?
Yes.
How is the respondent number 5 connected?
Respondent number, sorry, the respondent in the name of respondent number 4. Respondent number 4 is Thamazi District Baptist Association. Respondent number 4 is Thamazi District Baptist Association.
This is allotted in favor of
4.
4.
Yes.
By whom?
By respondent number 2.
Who's 2?
Respondent number 2 is the Deputy Commissioner. Deputy Commissioner, Dhamazi District.
So R4 is the Baptist mission.
Yes. And 5 is the representative of respondent number 4.
Okay, then.
Subsequently, in the year 2002, the annual patta was converted to periodic patta number 99 in the name of the respondent number 4.
In 98 annual patta was granted in favor.
Yes.
And thereafter, when it was converted?
2002.
To periodic patta.
Periodic patta number 99.
Okay. Thereafter?
That was subsequently came to the knowledge of the petitioners, and accordingly, revenue appeal was filed before the Board of Revenue, before the Deputy Commissioner itself, RA 75 DMJ 2011. RA 75 DMJ / 2011.
Before DC? Not before the DC, before ABR, I think.
No, before the Deputy Commissioner.
Deputy Commissioner?
Yes.
Okay, thereafter?
And while disposing of the revenue appeal, a report was called from the circle officer, that Dhamazi Revenue Circle. Kindly peruse paragraph number 22, annexure 2.
Page?
Page 22, Lordship.
22.
The final order passed by the Deputy Commissioner in the Revenue Appeal on 18/11/2011.
Date? 18 July.
18/7/2011.
What is it?
Says paragraph number, second paragraph.
Please read.
As per record, a plot of land measuring 8 bighas, 1 katha, 12 blessers under Dag number 4 of Gogamuk, Lagasu Nepali village
was under possession of Baptist Christian Association, out of which 2 acres of land was settled in the name of head office Dhemaji Baptist Mission under Dag number 4, periodic part number 99. Peru's circle officer's report, she stated that Sri Amiel Dole, that is the petitioner number 1. Amiel Dole has been possessing the land since 1994 till date, and a respondent association, that is respondent number 4, has got annual patta in the year 2000 and periodic patta in the year 2001 without possession. Without possession. The report also reveals that the Rajah Adalat held on 6/10/2001 converted the annual patta into periodic patta without field verification. Hence, the circle officer in her report recommended to give settlement of said plot of land in favor of appellant, that is the petitioner before this honorable court, who has possession over the disputed land. As per report of circle officer, the second party has land measuring 6 acres, 1 katha, 14 lasses, whereas their building of the second party are located. From that report of circle officer of Gugabmukh Revenue Circle, I am also of the opinion that the patta was wrongly issued in the name of the respondent Christian Association without any possession. However, I have gone through the content of memo of appeal and written statement of the respondents' related documents. The entire matter relates to the title of the disputed land between the parties. Therefore, I direct both the parties to approach the competent civil court for a proper redress. The appeal is disposed of on to the 18th. So thereafter, Lordship, the respondent number 4 and 5 had filed the title suit before the Honorable District Judge Dhemaji, Lordship.
Title suit before district judge, why?
It was filed before the deputy district judge, Lordship. But as because I think at that 11 point of time, the civil judge was not there. The title suit 4/2011 was filed.
Okay, who filed?
The present respondent number 4 and 5. Dhemaji Baptist Association and Arun Kumar Dutt.
They filed title suit 4 of 2011.
4 of 2001.
Yes,
11.
2011.
Yes. Kindly see the subject matter is at page 35. Schedule 1.
Page?
Page, Lordship, 35. Schedule 1, description of land, area of disputed land 2 acres, Dag number 4, periodic patta number 99, map Lagasung Nepali, Mauza Bordoloni, Dhemaji. So prayer Lordship is a prayer of the plaintiff, Lordship. Page number 35 itself, Lordship. Now the plaintiffs are praying to admit this suit and summons the defendants to pass decree of recovery of possession of the land and to recovery of possession of the building occupied by the defendants, Lordship. We contested the suit by filing our written statement, that is Annexure 4. Finally, Lordship, the suit was dismissed by the Honorable District Judge. The judgment is at page 46, Annexure 5, Lordship.
Page?
Page 46, Annexure 5. The judgment dated 18/2/2000.
Who is for the other side, Mr. Sharma?
No, they did not appear in spite of receipt of.
Okay, they have chosen not to appear.
Yes, yes. So suit was dismissed
But what about the RFA 35 of 16?
Yes, Lordship. Owing to change of pecuniary jurisdiction, initially the RFA was transferred to the district judge Dhemaji, Lordship. But technically, what the points have already raised by this honorable court, the judgment was passed by the honorable district judge himself, Lordship. So I got the information that subsequently that record was sent again sent back to this honorable.
Okay. So that is the, what is the development in the RSA?
Not yet listed, Lordship. So during pendency of this,
We can have both the matters together.
what may, Lordship, the matter may be disposed of with an observation that this will govern by the outcome of the regular first.
That can be done.
Yes, Lordship.
That can be done because, see, in the first order passed by the learned ADC on 18/7/2011, there is an opinion in your favor
Yes.
that the annual patta was issued without taking into consideration the fact that the respondent numbers 4 and 5 were not,
We're
in,
not
possession.
in possession. Yes.
So that is a very relevant observation.
Yes,
That is the basic aspect.
Yes, Lordship.
But at the same time, the learned officer has said that since there were disputed questions, the parties have to approach the civil court. They approached the civil court.
Yes.
And at that time, for what purpose we do not know, it was before the deputy for district judge. So it was dismissed, you contested, and thereafter RFA has been.
Yes. RFA number.
RFA 36 has been, 35 of
Yes.
16 has been filed. Now it is in the midst of, it is in the stage of hearing.
Yes,
We can close this. Close this.
Yes, Lordship.
Without a big.
With this observation, Lordship.
Okay.
With this
No, it's good
observation.
that you have narrated basic facts, we'll put it down and we'll close it. Okay. Heard. 3R Sharma. Learned counsel for the petitioners. Also heard 3G Hentic, learned state counsel, as well as Madam Anne Baudelaire, learned standing counsel, revenue department. Vera. This writ petition was instituted in the year 2018 with the following prayer. Vera. As per the facts projected, comma, in the year 1994, the petitioners who belong to the missing community were excommunicated. Full stop. For which they had to leave their ancestral place. Full stop. However, one Moniram Dole,
yes, Lordship,
had allowed the petitioners to reside in a plot of land measuring 2 bigha, and the petitioners continue to possess the said land. Full stop. However, in the year 1998, the Deputy Commissioner Dhemaji had allotted the aforesaid land to the respondent number 4, and the and in the year 2002, the annual patta was converted into periodic patta number 99.
Yes.
Full stop. The said action was the subject matter of challenge in an appeal filed by the petitioners, being RA 75 DMJ 2011. Full stop. In the said appeal, comma, a report was called for from the concerned circle officer. Full stop. After consideration of the materials on record, comma, the additional deputy commissioner, comma, Dhemaji, had passed an order dated 18/7/2011, in which a clear opinion was expressed that the aspect of grant of periodic patta was not proper, inasmuch as it was the petitioners who were in possession of the land in question. Full stop. However, comma, an observation was made that the parties may approach the concerned civil court. Full stop. It transpires that thereafter, the respondent numbers 4 and 5 had instituted title suit 4 of 2011 in the court of the district judge, Themaji. Full stop. The suit was contested by the present petitioners and the same was dismissed on 8/1/2016.
8/2/2016.
1 or 2? 8/2, right,
8/2,
right, you are 8/2/2016. Full stop. The said order is, however, the said judgment and decree is, however, put to challenge in RFA number 35 of 2016. Full stop. Para. I've heard Sri R. Sharma, learned counsel for the petitioners. I've also heard Sri J. Hendik. I could question you, bro. Sri Sharma, the learned counsel for the petitioners, has fairly submitted that since in the order dated 18/11/2017, there was a mention that the parties should approach the appropriate civil court, which was in fact done by the respondent number 4 and 5 unsuccessfully, and the said judgment is the subject matter of challenge, the present writ petition be disposed of with an observation that the orders which may be passed in the appeal would govern the field. Full stop. He has also informed this court that though the RFA number 35 of 2016 was initially instituted in this court, due to certain change in pecuniary jurisdiction, the same was remanded back. Full stop. However, it was detected that the initial order was passed by the learned district judge. That the judgment and decree was passed by the learned district judge Themaji, and therefore the records have again been transmitted to this court, and the same is pending final adjudication. Full stop. Para. Both Sri Hendik and Ms. Bordler, both Sri Hendik, Land State Council, and Ms. Bordler, Land Standing Council, has not raised any serious objection to the proposition advanced by the learned counsel for the petition. Para. This court is of the opinion that since the dispute is presently under consideration of this court in RFA number 35 of 2016, there will be no requirement to continue with the present proceeding. Full stop. The writ petition accordingly stands closed with an observation that the parties would be governed by the decision which may be taken in RFA 35 of 2016.
Much like.
Right, with your lordship.
Item 3, what is 3? Yes.
Yes, my lord, the son of the respondent number 4 in the year 2019 was studying in class 11 at the petitioner's institution, my lord. And he had some, my lord, behavioral and disciplinary issues. Initially, he was warned, and then, my lord, thereafter he was suspended twice for a single day, my lord.
Class 4?
Class 11.
11.
Stream, yes.
Okay. Respondent number 4 son.
Respondent number 4 son.
Okay. Thereafter?
Thereafter, my lord, the parents were called, my lord, they were informed. Counseling was given, no change in the behavior. In fact, my lord, once or twice, my lord, he used unconstitutional words against the teacher, my lord. Anyway, my lord, thereafter, my lord, the mother, the respondent number 4, applied for transfer certificate, which was accordingly given. Thereafter, my lord, she took him out and admitted the child in RNS Academy, Gauhati. Thereafter, she filed a complaint for corporal punishment and mental harassment before the State Commission for Child Life Protection, my lord. And the commission, my lord, after hearing both sides, has passed the impugn order on 24/4/2019, my lord, directing that we should take back the child, readmit him, and my lord, we should tender an apology. And while passing this impugn order, they have invoked Section 75 of Juvenile Justice Act. In my humble submission, my lord, the Child Protection Commission Act does not empower them to do so, my lord. So, my lord, invoking of Section 75 by the commission, my lord, unheard of, my lord. And corporal punishment, my lord, the definition itself defines that it is for inflicting pain for disciplinary measures. Here, my lord, the ingredients does not attract at all, my lord. At best, the commission can recommend to the government, but they don't have the statute doesn't provide them
Mr.
any
Nath.
penal power.
Well, the impugn order was passed on 24th of April 2019. And the respondent number 4, although the service has
Is R4 appearing?
no, R4 is not appearing, service has been completed, she is not appearing, she is not interested.
Okay.
But before I
But
take-
R4's son is probably in some other school.
in 2019 only, he got transferred, he passed 11, 12, he passed, and possibly they forgot. In my respectful submission, this, otherwise the matter has become infractious. This, whatever the grievance has been raised by the petitioner here. This is an academic, as on today, my lord, it is an academic discussion.
But there is an order which needs to be either affirmed or interfered with.
But
The commission's order is there to seek readmit him. Readmission may not be a practical, they may not even insist upon it.
already transfer certificate has been taken
And for apology to whom?
apology to the parents, to the respondent 4. And respondent 4 is not,
We can pass a via media order since they are not also not contesting.
not logical. So in a proper.
And what about the arguments on jurisdictional aspect?
In fact, the order itself at Annexure 12 is a detailed order. And the
But the powers of the commission?
yes, under section 13, 14, and 15, the power of the commission has been defined.
So,
And in fact,
which is the act?
look, this is Commission for Protection of Child Rights Act 2005.
Okay.
They have given us.
We have.
that, yes, right.
Yes, we have.
Detailed power has been given, and ultimately the object of the commission is to see the best interest of the child. The order is very detailed order. If logically comes to section 13, function of. the
But
commission-
all are recommended in nature.
True,
Where is the impugned order? Let us see.
logic.
Yes, Annexure 12, my lord.
Page 44. In fact, commission has referred to section 13, that page 44 kindly come, 44.
That says page 44.
Till procedure has been followed, they were summoned, they were heard, the statements have been recorded. And thereafter, they found that the mental harassment has been inflicted on the students. That is the finding of the commission. Kindly note the
Recommendation.
page 44, this is addressed to the petitioner. Commission took cognizance of the matter under section 13 of the Commission for Protection of Children Act 2005 and reviewed the complaint. After reviewing the complaint, the commission identified the action as corporal punishment and mental harassment to the child. The commission therefore recommended the school authorities write its letter addressed to the principal of the so-and-so school, write its letter number so-and-so dated 30th of March 2019. That the student should be immediately admitted to class 12 so that he does not lose one academic year. The commission also requested the school authorities to submit an action taken on the recommendation of the commission at the earliest. Then commission received letter from the principal of so-and-so by number dated 20th of March 2019 in response to its recommendation letter. Through this letter, the school authority has mentioned that the action taken against a child was for his betterment, and as per them, it does not amount to any corporal punishment or mental harassment. Further, in the concluding paragraph of the letter, it is stated that they have quoted,
then commission has recorded, thus commission in exercise of power under vested upon commission under section 14 of the Commission of Protection of Children Act 2005, summon the attendance of the principal of the so-and-so school, MS so-and-so subject teacher of the state school to appear before the commission on 1st of April 2019. Following the same, the so-and-so principal of the principal.
But Mr. Nath, Mr. Patwari also,
My lord.
at page 48,
Yes, my lord.
it is only recommendation.
Yes.
It's not an order, not an order, recommends that.
Yes, this is a recommendation.
Recommends that.
No.
Recommendation power they have, the commission has. It's
No.
not ordering.
No,
This recommendation has to be acted upon by the government to enforce it.
Yes, but they're not forward there. Considering the above facts, the review of instance, the commission feels that such action by the school authorities is not in the best interest of the
Yes, how do you resolve this? Was he says that based on the police report and pleadings that there was a flood situation.
Lordship.
And your contention is that there was no flood and the drowning had happened in a pond.
Lordship.
In that case, your notification of 2 lakhs will apply.
Yes, Lord.
And if it's during the flood and council has also drawn the attention of this court to the expression including.
Yes.
That means victims perhaps also.
Lordship.
So 4 lakhs. But the question is whether it's during flood or otherwise.
In his representation, Lordship, NXI, he did not mention about anything about the flood law.
Annexure page.
Is 27. In the vernacular law. কন্যার পানিত পৰি মৃত্যু হয়।
গতিকে 26A
26
কিন্তু অতি দুখৰ বিষয় যে যোৱা 24 তাৰিখে মোৰ কন্যাৰ পানীত পৰি মৃত্যু হয়।
No mention about the flood. Flood.
Or something that she was washed away or something like that. Have you received anything? What is your name, Mr. Counsel?
Yes, Ahmed.
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 Have you received anything till now?
My lord?
Any compensation? Have you received any amount?
No, my lord.
Nothing.
No, my lord.
But you are admitting, Mr. Goswami, you are admitting to the extent that 2 lakh will be entitled.
Yes.
Mr. Ahmed, the other aspect is would come within the realm of disputed questions. You are saying flood, they are saying there was no flood.
My lord.
So you have to prove it that thing cannot be done in a writ court.
Yes.
What we can do, so far as their admission is concerned, 2 lakh, we'll say, and if you think that you still have a claim for 4 lakhs, as per then you have to file a civil case and prove that it was at the time of flood. Do you have evidence? This case was of which year? 19?
But litigation is started now, 23.
Huh?
Litigation filed in 2023.
Author 23.
19.
Why are you so late in coming to the court?
My lord.
Why are you so late in coming to the court?
My lord, actually, writ petition was filed on
23.
23.
no, my lord, writ petition,
Once
one writ
withdrawn.
petition filed on
21.
21, my lord.
Okay. Thereafter,
Then there was technical difficulties and it was withdrawn.
Okay.
23.
And next 23 it was filed.
or 21 they had come. There was no
My lord.
such delay as such.
Yes.
That was caused. So 2 years will not be a substantial delay. Okay.
In our affidavit, we have mentioned, but not due to flood situation. That is there also.
Heard 3A as Ahmed Learned Counsel for the petitioner. Also heard 3N Goswami, Learned State Counsel, 2, Miss N Borderloy, Learned Standing Counsel, Revenue Department, and 3 BC Musahari, Learned Standing Counsel, BTC. So the present writ petition has been instituted with the following, seeking the following relief. Para. As per the facts projected, the daughter of the petitioner, Damini, please have your seat. Damini Basumatari was a student of class 10. Who was a student of class 10, had met with an accidental death on 17/7/2019 during the flood situation. Full stop. It has been contended that she was washed away in the heavy flood, and the matter was immediately informed to the Boroma police station, whereafter UD case number 5 of 2019 was registered, culminating in a police report dated 30/8/2019. Full stop. The petitioner had thereafter made representations for grant of relief / financial help. Full stop. The petitioner has relied upon a letter dated 8/4/2015 and has claimed the relief of ex gratia. Full stop. Para. Sri Ahmed, the learned counsel, has submitted that as per the aforesaid notification dated 8th April 2015, ex gratia payment is prescribed at rupees 4 lakh. Full stop. He has submitted that the facts are not in dispute that the death of the daughter of the petitioner was a result of the flood situation. Full stop. He has also drawn the attention of this court to the police report dated 30/8/2019, as per which the death was caused when the daughter of the petitioner fell in a deep watery canal. Full stop. Para. Per contra, comma, Sri Goswami, the learned state counsel, has submitted that while the aspect of death of the daughter of the petitioner is not disputed, comma, there is a dispute with regard to the nature of the accident. Full stop. He has submitted that there was no flood as such, and even in the application made by the petitioner, there was no mention of any flood. Full stop. He has also drawn the attention of this court to the affidavit in opposition filed by the respondent number 2 on 16/3/2026, wherein the aspect of flood has not been admitted. Full stop. He submits that if any compensation is entitled to by the petitioner, comma, it would be under the notification dated 15/11/2014,
Yes.
which prescribes a compensation, an ex gratia of rupees 2 lakh. Full stop. The aforesaid submission made by the learned state council submissions have been endorsed by both Ms. Bordloy, the learned standing council, Revenue Department, and Sri Musahari, learned standing council, BTC. Para. While the aspect of death of the daughter of the petitioner is not in dispute, comma, the aspect as to the specific reason of such deaths is disputed. Full stop. While the petitioner is contending that his daughter was washed away in the flood, comma, in the police report dated 30/8/2019, the same has not been directly reflected, and rather it has been written that the deceased had fell in a deep watery canal. Full stop. This court has also gone through the application filed by the petitioner seeking compensation, wherein the aspect of flood has not even been mentioned. Full stop. Why have you in your In your English translation, why have you used the expression flood? Was there any flood? In the Assamese, in the vernacular, there is no expression of banpani. Why have you written flood in the translation? Should not have. You be fair to the court. Whatever you are entitled, will definitely give you. Is there any expression of banpani in your vernacular? No. There isn't. You have simply said konyar panit puri mrityu hoise. Mur konyar panit puri mrityu hoise. But in the English, you have said, my daughter was, but unfortunately on 7/7/2000, my daughter was due to death in flood situation. What kind of translation is this? কি করলো last ওখানে? Mentioned. In this regard, the vernacular, the original application in vernacular has also been carefully perused. And it appears that in the English translation, and it appears that the English translation was not properly done. Para, be that as it may, since the aspect, since the respondents have acceded to the extent that it would be the notification dated 15/11/2014, which may be applicable, the respondents are directed to take necessary steps for processing the ex gratia which is prescribed under the said notification. Full stop. The petitioner is required to furnish all the necessary documents to the appropriate authority to initiate and finalize the said process. Full stop. So far as said process. In case the petitioner is having a claim for benefit under the notification dated 15, 8/4/2015, since the matter would come within the disputed questions of fact, the petitioner would be at liberty to approach the appropriate civil court for relief if so advised. Writ petition stands disposed of. You furnish the documents immediately so that they can process. Yes, who is
Mate,
9?
Yes, Sama. Mate,
Mr. Sharma, please call Mr. Sharma.
Please, outside the court.
Central Bank of India.
Union Bank of India.
Union Bank of India.
Union Bank. Who's here?
Yes, what is
Mate,
this?
present. In this case, the petitioner has taken a loan of 1 lakh for pursuing her PhD course, Lordship.
Okay,
In
we
2015.
take up for final disposal, Mr. Sharma.
Let's.
Yes.
That's it.
You took a loan
Loan
of 1 lakh.
1 lakh. For 1 lakh, for a period of 2 years only for pursuing PhD student, PhD course. Lordship.
From the respondent bank.
Respondent bank.
For 2 years.
For 2 years.
Thereafter,
Thereafter, she paid the installments up to 2018.
When did you take the loan?
Look dated 12/4/2016.
12/4/16.
2016.
Then
Then Lordship, the loan EMI was paid up to 2018.
what was the schedule of payment?
Schedule number was 1968. 1968
1968 means?
EMI, 1968 per month EMI. 1,968.
Rupees 1,068
968
per month.
per month
That was the EMI.
EMI
Till 2018, you had paid the payment. You made the payment.
payment.
Thereafter,
Lordship, I could not pay my payment, and after that COVID has come, I could not pay, and I approached before the bank authority
yes.
on page number 13, 25/5/2020. That page number 13.
You filed an application.
Application.
Thereafter,
Application was that for them that I will give all the payment till date, and you give me 3 installments time, and I will pay all the money. Till
you
date.
rather you sought for a plan, a new settlement plan.
Yes.
That within-
Yes, Lordship.
Okay.
Because I pay before the bank not to calculate the compound interest. This was not considered. Then I again approached before the regional manager. Application has been filed on 17/2/21. But however, some payment has been made during the time also.
Yes.
It has been clarified from their affidavit and my affidavit also. And when no action has been taken, then I approached before this honorable court.
Earlier.
No, in this petition.
Okay.
I am in this petition, and in this petition given an interim order that no coercive actions should be taken.
Which order?
Order dated 31/3/2021.
Okay.
After 21 also, after this order, also I am paying some money, Lordship. Sometimes 500, sometimes 11,000. That is in their affidavit, Lordship. It is not this book. Now, Lordship, what happened? In this loan, I have given to mortgage to LIC policies. It is not belong to me. It is other persons. And my pay was to not to disturb the LIC policies, because I will pay entire money. And they did not consider and did not given the answer, and they are not calculating what has to I have paid. And now they have filing affidavit. By this affidavit, they have said that in spite of the court order, the LIC policy, which has been adjusted on 4/12/2024.
21.
Which nil bill? 24 Niki?
21.
24. They have adjusted it.
When? 4/12?
4/12/2024.
24.
24.
Mr. Sharma?
It is perhaps wrong.
That in their prayer, they have made only 2 prayers. That number 1 is the LIC policy should be returned to them. And number 2, that they should not be charged with a compound interest. So compound interest is a thing that arising out of the agreement.
Contract.
That is, we have not deviated from that part. And as far as the LIC.
How much is there now outstanding?
Your lordship, it is nil now.
Nil.
Yes. After adjusting the LIC
No.
policies.
If you do not adjust, how much was the amount in the LIC?
Your lordship, that is, we have adjusted two transfers. One is 92,744 and another is 93,051.
Almost 2 lakhs.
Yes, your lordship. because they have not paid the amount from since 2016.
No,
Say no, see, till
2018.
till 18 they have paid. Till 18 they have paid.
No, your lordship.
not it.
Your lordship, I have placed before your lordship a statement of account. They have not paid their regular EMIs.
Yes.
What they have done, they have paid in lump sum amount like 9,000, like 3,000 in such a manner. And interest is getting accrued and interest is getting cumulative also. Because suppose today is 110, by the next month, again on 110, the interest will be charged.
Correct.
That is the issue, your lordship. And they
But,
have not come out with any payment.
Hmm?
They have not come out with any payment. They keep on making the proposal to the banks only.
Your PhD has been done.
Chief, therefore, Lordship, because
Have you done your PhD?
yes, Lordship.
PhD done.
PhD done, Lordship. It's not PhD done. Now she is like doing lecture in a particular college.
Now, if the LIC policies are returned to you, will it come or will it be of any use?
It is not for me. It is for another person, Lordship. I have to return. Because I am ready, because in the affidavit, Lordship, I am ready. I am admitting that I am going to give this repayment.
Mr.
But LIC
Sharma,
policies,
you take instructions, come up with your proposal, how much he needs to pay.
Your lordship, today there is nothing
Huh?
because we have.
No, if you have to return the policies.
Your lordship, it cannot be possible because we have surrendered the policy before the LIC and we have received the money from them
And the
because
court-
it is placed with us.
and court
And
will
the rule of the pledged is very clear, your lordship.
Court order is there.
What about the stay order?
No coercive action. Bank already.
Your lordship, by
2000.
that time, there we have not been communicated because.
No, this interim
notice has
order,
been served
interim
upon
order
us very
31.
recently.
The interim order 31/3/2021.
Yes, but notice has served upon us, your lordship. With no communication. your lordship.
How is it possible? How is it possible?
In the affidavit, I have written that it has been communicated.
He secures an interim order, he'll not serve. How is it possible?
Just a minute, I am coming back here also.
And when was the adjustment done?
Huh?
Adjustment done when?
It is.
24.
Your
Huh?
lordship, I am saying.
4/12/24.
21.
Huh?
21.
21 or 24?
21, your lordship.
Here 24 has been written by
No,
the.
no, account was closed on 24. But the transfer entry is of 2021, your lordship. That is on 31/12/2021 and another entry is 24/2/2022.
24 to 21.
31/12/2021.
31/12 and
Amount rupees 92,744. And on 24/2/2022, amount rupees 93,050.
0.
51. 51.
So what relief can be done, Mr. Mahanta?
Lordship, I have submitted application on 2020. That on the filing of the application, Lordship, I'm categorically stated that I'm going to pay. Please give the.
No, what relief can you get now?
Lordship, LIC policies can.
LIC policies have been surrendered by them. They have been paid the money.
Lordship is violating the court order, Lordship.
Now, you can file a contempt. Let us see where you have stated that you have submitted to them.
Lordship.
Your lordship.
25.
The first order was issued on 31/3/2021.
Yes, stay order, no coercive action.
And thereafter, we have appeared on 3/7/2023. And
No,
it got time to.
No, Mr. Sharma, your appearance is not material. What is material is where you served.
Yes, your lordship.
When
That
did you
they
get
can
the
prove it.
when did you get the information about the
Yes,
stay order?
yes, your lordship. Yes.
Because this initial order was an ex parte order.
Yes, sir. I have
So
to-
it needs to be served upon you.
Yes.
When was it served?
That is, I have no knowledge, your lordship. I have to check out with the bank or the court case accordingly.
এত লেখা নেই এমনি কেটে আছে। ডিমোগাত আমি কেতিয়া দিলো এই বেংকত
There is no endorsement in the office note regarding the date of receipt of service. It was sent, it was issued on 7/4/21. And you entered appearance in 25/11/22. Mr. Mohanto,
Lordship.
contempt would be applicable if you can
Yes.
make out a case that they were aware of it and yet they had willfully defied.
Lordship.
But there is nothing on record to
Nothing
show
on-
that it
yes.
was served upon them.
Lordship. Lordship. I also go to this
Mhm.
when it was served. ऐसा नहीं किया मैंने।
But how do you resolve this issue? Is there anything? And what relief can we grant you, Mr. Mohanto? You see the prayer. After these are surrendered, as on today, there is no outstanding. He has very fairly said.
No,
But you are more concerned with the LIC
LIC
policies,
policies.
which you have to return.
নহয়, কেতিয়া পঠাইছে নাই ৰেকৰ্ডটো। মোক কপিটো দিবগে লাগে তো বেংকক গৈ পেলাই কপিটো দিয়া হেৰিটোৱে নাই। Lordship may dispose the matter. I will file contempt if it has been given by the.
But you have to make out a case that they were aware of it, yet they had.
Lordship.
Because if you come to the prayer at page 7, you said that why compound interest should not be exempted. Now compound interest has also already been levied, amount has been liquidated or adjusted from the LIC. Now there is nothing. If you can make out a case of violation, contempt is there, you can also file for compensation,
Lordship.
damage.
Lordship.
Do you have anything on record, Mr. Mohanto, that it was served upon them? Otherwise, it will be difficult for you.
Lordship, can it be tomorrow, day after tomorrow? I'll
Monday.
Monday, Lordship. Monday. If there is nothing,
Monday?
Lordship.
Monday may not be given.
Tuesday.
Tuesday or Wednesday.
Tuesday.
Lordship.
Okay. Heard Sri D. Mohanto, learned counsel for the petitioner. Also heard Sri M. Sharma, learned counsel for the respondent, Union Bank of India. Para? On a prayer made by Sri Mohanto, matter is adjourned to be listed on Tuesday next date to enable him to obtain further instructions.
Obliged. 21.
Item 20.
May I please join?
Yes.
I may be allowed to withdraw the case, Lordship. The matter become impactful, Lordship.
I am appealing from respondent number 124 here. Petitioner has already paid the loan amount and the proceeding pending in the court of Metropolitan Magistrate at Kolkata has already been withdrawn by us here.
Okay.
So
The
matter
loan has been liquidated.
Yes.
Okay. What is your name, madam?
Miss A. Begum.
Heard Miss A. Begum, learned counsel for the petitioners. Also heard your name?
P. Neu.
Also heard Sri N. Goswami. No. Also heard Sri P. Neu, learned counsel for the respondent numbers 1, 2, 3, and 4, as well as Sri N. Goswami. Who is 5 and 6? What are you doing here? Today, West Bengal is something is happening in West Bengal today. So you should be there. Miss P. Bhattacharya, learned counsel for the respondent numbers 5 and 6, within bracket, State of West Bengal, and Sri N. Goswami, learned State Council. Para. It has been jointly informed that the that the loan amount has been liquidated. And in fact, the respondent bank has withdrawn the proceeding which was instituted in the state of West Bengal. Full stop. Ms. Begum, the learned counsel, has accordingly submitted that the subject matter has become infructuous and the writ petition may accordingly be closed. Correct? In view of the above, writ petition stands closed. Bengaluru, Azir, Bengaluru. Bengaluru, Azir. Both, sir, both reasons. Didn't I know? Article 21.
The case of the petitioner,
Mr. Mukherjee.
Lordship. The petitioner's husband used to run a shop, Your Lordship, on the strength of a trade license. And during the currency of the trade license, he passed away, and the shop was being run by the wife, who applied before the municipal authorities to transfer the trade license in her name. And the municipal authorities insisted on a NOC from the landlord because there was a landlord-tenant dispute with the landlord. She said that she cannot obtain that and prayed for transfer it in her name.
Yes, madam, anything?
Your Lordship, my senior is on legs in another court.
Who is your senior?
SC Vishwas.
He was there, Vishwas was there around. What has happened?
He is arguing in another court, Your Lordship.
We wait for a while. Can it dispose of, Mr.
It can be disposed of. Pleadings are exchanged already.
Okay, we wait for a while then.
Lordship.
In the instruction where the permission was not given. Lordship, here, Lordship, you see the instruction that they are not aware of that order 11-11-25, page 24. My lord, can be disposed of directing that to you according with this.
What is it?
For permission of lottery.
Permission to conduct lucky draw.
Lucky draw?
Lucky draw lottery.
Lottery.
Is it permissible?
Lordship.
Lucky draw is permissible. Lottery is banned.
Lucky draw gift coupon.
Page
24.
Where is it? Which place? Ujai.
Ujai. My lord.
What is the first prize? Mercedes Benz. It's possible. You are the organizers.
Yes.
What is the first prize?
Ultra bus.
Many of the bar members may be also interested to have a Mercedes Benz.
No. Simple lucky draw.
Simple lucky draw. Fortuner.
Page 27.
27.
It's not clear in this.
If you have the fortune, you can have a Fortuner. What is the first prize?
Publisher proposal.
Are you actually paying the price? You do not even know what is the price.
My lordship,
Mr. Chakraborty may know the price. Yes, Mr. Chakraborty. You are interested in lucky draws. Hojai lucky draw. What is the first prize? Fortuner or Mercedes?
Scorpio, my lordship.
See, we said something of that kind.
Scorpio. Page 27. I have another picture, my lordship.
Picture also. Is it permissible, Mr. Roy?
Page 24, yes.
20?
4.
24.
District administrator is not aware of this order. That's why it was not given.
Okay, by following this, they can.
Yes,
Okay. We can dispose this of.
Lordship.
What is your name?
N Islam.
Hmm?
N Islam.
M Islam.
N.
N. Third 3N Islam Learned Council for the petitioner. Also heard 3S Roy Learned State Council. who is one?
One is
Finance, State Council, as well as Miss, no,
H.
H. Alia is there. H. Alia, Standing Council, Finance Department, para. Considering the subject matter involved, comma, this writ petition is taken up for disposal at the admission stage, para. As per the facts projected, the petitioner is a registered society and with an objective for collecting funds they had organized a lucky draw in the locality. Full stop. The petitioners had accordingly applied for permission from the District Commissioner Hujai to hold the draw on 31/3/2026, but it is already over, 31/3.
It was not given to them.
Okay.
They were asked for, but that
Full stop. However, in spite of the claim of fulfilling the requisite conditions as per the memo dated 11/11/25, no permission was granted. And accordingly, the instant writ petition has been filed. Para. Sri Islam, the Learned Council for the petitioner, has submitted that the aspect of lotteries and lucky draws were considered, was considered by this court in WPC 6090 of 2024, which was disposed of wide order dated 30/7/2025. Subsequently, the Finance Department had issued an order dated 11/11/2025, laying down the guidelines. Full stop. It is submitted that when the guidelines were provided, without taking recourse to the same, the permission has been mechanically rejected.
not rejected, Lordship, not yet been done. Not yet.
The consideration was not done. Para. Sri Roy, the Learned State Council, has however submitted that it clearly appears that the district administration was not aware of the order dated 11/11/2025 issued by the Finance Department. Full stop. He fairly submits that a direction can be issued for completing the said lucky draw strictly in terms with the order dated 11/11/2025, which has been issued in accordance with a direction of this court passed in WPC 6090 of 2024. Para. This court has carefully perused the order dated 11/11/2025 issued by the Finance Department in the context of the Lotteries (Regulation Act 1998) and the Lotteries (Regulation Rules 2010). Full stop. After a threadbare discussion, the Finance Department has laid down certain guidelines for holding lucky draws. Lucky draws during certain festivals. Full stop. It also appears that while the petitioner had requested for permission, the aforesaid guidelines do not appear to have been overlooked. Full stop. Para. In view of the above, comma, the Deputy Commissioner Hojai is directed to consider the application for permission submitted by the petitioner strictly in accordance with the guidelines laid down in the order dated 11/11/2025. And upon such permission, comma, the draw can be held, which however has to be strictly in accordance with law. Para. Petition stands disposed of.
Item 26, copy list.
My lord, the petitioner is the principal of West Gauhati Commerce College. My lord, the college was established in 1992. And my lord, the impugned judgment is at page 89 to 92, my lord, Annexure Q.
Judgment, you're challenging some judgment?
Yes, my lord.
By whom?
Me,
The state
appeal,
officer.
Before the honorable district judge.
Or you had preferred an appeal under the Public Premises Act?
Yes, my lord. Section 9.
That has been decided against you?
Yes, my lord. Basically, that it is unauthorized occupation.
Okay.
Citing to Supreme Court.
That decision is, there is no further appeal in such decision?
No. So we will have to file
Writ petition.
writ petition. So accordingly, we have filed in 2019 and status quo order has been passed. But in the meantime, some subsequent developments are there. On the last occasion, up to 2020, my lord, the college has not been provincialized. After that, the college has been provincialized. So some inspection report is also there regarding that land aspect. So, my lord, I am be allowed to file additional affidavit. Yesterday, my lord, I have talked with the principal, my lord. Day before yesterday, I could
No,
not
but
appear.
the aspect of your provincialization or will not change the status of the land.
My lord, since, my lord, there are several cases pending regarding that Kamakya temple land and other, my lord, plot of lands, my lord. The demarcation issue is there. My lord. And several
How much land are you occupying?
near about 2 bighas, my lord.
It belongs to railway land.
My lord, it is in the vicinity of railway land.
No, railway claims, and the order also states that order fortifies their claim
My lord.
and had directed for your eviction.
My lord. So, my lord, since, my lord, that demarcation process has not been completed, and on the part of the
Can you resolve the issue?
earlier division bench judgment was there.
Can you resolve the issue, Madam Bora? It's not a private individual, it's a college. Both are important. Railway is also very important, even college maybe to some extent. But it depends on how much encroachment has been made. If it is deep encroachment, then perhaps you cannot.
We have annexed the document, our that land document, lordship, annexure 1. That whole area regarding 766 bighas, the Pandu area, lordship, or really, lordship. Since 1986, lordship, we are giving them eviction notice. Every time they approach this honorable court and got some order, the honorable court never state the eviction process, but only says with following due process of law, they should be go ahead. So never interfere with the eviction process.
Regarding
They filed 4, 6, 7 cases writ petition before this honorable court. Lastly, the honorable court directed to approach the district judge under section 9 of the Dissemination Act, Public Premises Act.
That has also been dismissed.
Yes.
And he is aggrieved by the decision.
Yes. The honorable district judge has clearly stated, lordship, they admittedly a land grabber, lordship, they had mentioned the honorable district judge. Phase, lordship, judgment is from phase 6.
89 to 94.
Last page is not
Last
there.
2 pages, 93 and 94.
Not there.
That's it, true. 93, para 10 onwards, my lord.
Since 1993, Lordship, we have submitted, filed the FIR also, everything, Lordship.
In para 11, my lord, this college has been
Are
turned
you, how many students do you have?
near about 2,500, my lord.
2,500.
Yes, my lord.
But 93, we are
And,
filing FIR, Lordship, because
That
every time.
regarding that crucial aspect of demarcation, my lord, the railway is silent, my lord, for last 15 years.
No, not silent, Lordship, we have filed a FIR also. Every time they approach honorable court.
But
for
that
giving
regarding the
every job,
demarcation process, my lord,
take any action against this college. When we
District-
check the writ petition, Lordship.
at the
But
behest of the
problem-
district administration, my lord, demarcation process has been initiated.
Since they are in process.
So, my lord,
Because
the
going through the records, all these documents, Lordship.
affidavit,
Document all.
affidavit of
There
the
is no
state,
title over the railway land, Lordship, how they are constructing the college, Lordship, it is very, they did not care about all these things.
Where is the location exactly?
Pandu Borigaon, my lord, far away from that.
Goripara, Pandav Nagar.
Earlier it was Ram Sarani, now it's Gaurapandu Kumar Parait.
Then we'll decide the case, we'll see whether, we'll decide strictly in accordance with law, whether the order passed by the learned district judge
Yes.
as the appellate authority has taken into consideration the relevant factors, certiorari jurisdiction. If you can make out a case that extraneous factors have been taken into consideration, we interfere, otherwise we have to agree with the learned district judge.
Yes, Lordship.
Yes,
Yes, in the last list, paragraph 15, in the instant case, the appellant has got no legal right, title and or interest. in
no,
the-
Madam
Again,
Bora, now our consideration would be on a very short confinement. Earlier round of litigation has sent him to the to file an appeal.
Yes,
So we'll
yes,
not, cannot go back. Now we only have to examine the legality of the order passed by the learned district judge. Who are these, the materials before him? We'll just examine and we'll pass orders, whatever is there. Yes, what is wrong with the order?
My lord, regarding that, my lord,
Let us read the impugned order,
my lord,
page
page, it starts from page 89, my lord,
89.
annexure Q, my lord. I take your lordship straight to para 9, 10 and 11, my lord. May I pray, my lord, for hearing the entire matter, my lord. I will require some time, my lord.
We have all the time for you. All the time. Thursday is meant for hearing.
Can it be in the
18, this matter is of which year? 19 matter.
19 matter?
Please argue.
My lord, can it be on Tuesday, my lord?
No, please argue. You do your part, we'll complete it.
My lord, I am not entirely ready, my lord, partly ready.
Let us see, let us see.
On Tuesday, my lord, it will be
No,
better.
Tuesday, we have not seen a Tuesday. It might never come Tuesday. Let us finish it today.
Then
What
tomorrow,
will happen
at
today?
least-
Tomorrow will not be possible, Friday. Let's try, just read the order, page 89.
My lord, I take your lordship straight to page 89, my lord, the judgment, my lord.
2023-19.
2020 March 2019.
19. Miss
Judge-
Appeal,
judge-
10 of okay. This was filed as per direction of this court.
Yes, my lord.
Okay.
Mary.
Yes, please.
This is an appeal filed under section 9 of the Public Premises Eviction of Unauthorized Occupation Act 1971 by the principal of the West Gauhati Commerce College, Boripara, Pandavnagar, Gauhati, praying for setting aside and quashing the impugn order dated 15/2/2018 passed by the State Officer NF Railway, Maligaon, Gauhati, respondent number 1 in eviction case number so-and-so. 2. The case of the appellant in brief is that he is the principal of West Gauhati Commerce College, having concurrence, affiliation, recognition from the state government, Gauhati University, Assam Higher Secondary Education Council, which was established in the year 1992 at Boripara, Pandavnagar, Gorpandu, Gauhati, so-and-so in a plot of land covered by DAG number 18 under Jalukbari Mouza in the district of Kamrup Metro, Assam. 3. On 3/3/2010, the respondent number 1 served a notice upon the appellant to show cause honor before 15/3/2010 in connection with eviction case number so-and-so, and the college authority submitted its reply. Over the same, the parties fought protected litigations in this court and before the Honorable Gauhati High Court, and ultimately, the respondent number 1 issued the show cause notice dated 22/11/2017 in connection with eviction case number so-and-so, and the appellant duly participated in the said eviction proceeding, though through his engaged counsel, but without taking into account the pendency of the WPC number so-and-so before the Honorable Gauhati High Court, and without according any opportunity and without considering the factual and legal metrics of the case, by the impugn order dated 15/2/2018, the respondent 1 directed the appellant to vacate the railway land from which the West Gauhati Commerce College has been functioning. Aggrieved by impugn order dated 15/2/2018, the appellant preferred this appeal on the following amongst other grounds. Ground 1. For that, the contents of the notice dated 3/3/2010 in eviction case number so-and-so, along with its reply communication and other documents, including earlier eviction order dated 4/3/2013, judgment and order dated 15/3/2017, including earlier eviction order dated 4/3/2013, judgment and order dated 15/3/2017 in Miss Appeal number so-and-so by this Honorable Court vis-a-vis the legal aspects of the matter have not been gone deep into with their proper perspectives, and consequently, the impugn order dated 15/2/2018 has been passed by the respondent state officer without considering the merits of the case in its entirety. Further, the impugn order of vacation eviction dated 15/2/2018 by the annexer P has not been passed in eviction case, notice whereof has been issued on 3/3/2010 by the annexer D. For that, there has been error in law, jurisdiction, as well as in facts, and proper reliance has not been placed on the available records of the eviction case and or other relevant aspects of the matter. For that, neither any document has been allowed to be submitted in the said eviction case within a reasonable period, nor relevant records have been allowed to be placed prior to passing the impugn order of eviction, granting proper, adequate, and full opportunity to the present appellant in the aforementioned long-pending complex eviction case. 4. For that earlier relevant High Court judgment and orders, including a division bench judgment and order, as well as pending High Court cases as regards the same land area, have not been looked into and are considered prior to passing of the impugn order in an undue haste, though the respondents were well aware about those judgments and orders. At that time, my lord, some High Court cases were pending, including one filed by one Kamal Boyce regarding that Kamakhya temple case. On a stay order was there. It has not been, my lord, reflected in the judgment in the later part. For that, impugn 5. For that, impugn order is against the relevant provisions of the aforementioned Public Premises Act of 1971 as amended, wherein it is clearly laid down that before an order of eviction is passed, there are certain serious legal formalities which cannot be ignored, and no authority respondent can be allowed to take resort to jump over the stages as mandated in the said act, particularly in view of the judgment and order dated 15/3/2017 in Miss Appeal number so-and-so by this Honorable Court. 6. For that, this honorable court on earlier occasions granted sufficient reliefs and protections under the aforesaid Public Premises Act of 1971 to mere individual interests prior to resorting to eviction operations and or passing of order of eviction. The aforementioned college being a public institution having concurrence, affirmation, recognition of the state government, University Higher Secondary Education Council is sought to be denied with similar relief of protection. Next, ground 7. For that, there for that, there has been mysterious silence as well as suppression of material facts, including purported eviction order dated 31/3/1998 by the paragraph 5 to read petition bearing WPC number so and so annexure F, and or subsequent eviction notice dated 3/3/2010 by the annexure D by the respondent state officer while passing the impugn order. 8. For that, the land in question has not been demarcated as railway land and it is still a disputed plot of land. It is very crucial aspect, the demarcation aspect. 4. The respondents have contested the case and a record of the eviction case number so and so was called for and the same has been received. Peruse the record. I have carefully examined the impugn order dated 15/2/2018, the memorandum of appeal, the record of the eviction case number so and so, and heard the arguments advanced by the learned counsels for both the sides. 6. During hearing, the learned counsel for the appellant vehemently argued that the respondent number 1 erred both in law and facts in passing the impugn judgment and order, in as much as there is no evidence, oral or documentary, to sustain the impugn order. Therefore, the appellant has prayed for setting aside the impugn order. Milord, regarding the demarcation aspect, it has not been reflected, Milord. In my arguments, Milord, one of my focusing points in the arguments was regarding demarcation aspect, and another one, the pendency of some cases regarding the said plot of land, including Kamakhya temple land. Stay order was there, but these are not reflected.
But how is it connected? Kamakhya temple land
Milord,
with this plot?
that is why, Milord, that demarcation is required. And
No, yours here is in the extreme corner. It says that you are only holding a plot of 2 bighas of land.
so that is why, Milord, that demarcation is required, Milord. And this once, Milord, that
But your first obligation to show any document to either show ownership or how do you claim possession, that is not there. How did you come into possession? Did you buy the land?
Milord, same thing applies to NF Railway also, Milord. Since, Milord, they claim that it is their land, but
Are you trying to equate an NF Railway with a private person?
it's not a private person, Milord.
NF Railway is almost the Union of India.
Milord, but it's Milord.
How do you equate that NF Railway has to? What is your private person? You have to show your title to the land.
It's a public institution, Milord.
Not public institution. How do you get the land? Did you buy the land? Where is the transfer document?
Milord, I'll have to, Milord, bring some documents.
No, not now, at the High Court stage. This is from 2010, 16, 26 years, 16 years have passed.
That is where some RTI applications have been, Milord.
For your document, you need to file RTI.
Milord,
For your land document.
not regarding that, Milord.
What does it portray? That is, you do not have any document. It's your document.
Milord, since it's they claim that it's NF Railway.
It's not their claiming. Just show us something that this land possessed by you belongs to you. There is a lease, there is a transfer, there is inheritance, anything.
Milord,
there is no such document. That is the finding, clear finding. We have read the judgment.
but the documents, Milord, I have sought for in my RTI applications, Milord.
Your document.
Milord, some documents, Milord.
Your document. You'll seek under RTI from whom? From yourself. You have to file RTI to yourself. Please give me my document.
Milord, may I draw your lordship attention to page 77 and 78?
Yes, please.
RTI.
No, those are, we have read the judgment.
My lord,
Any document which shows that you have a valid right over the land, either by a lease or by a transfer or by a sale, just kindly show it to us. Matter ends there.
my lord, that is why, my lord, I pray for some time.
That is why we are not giving you any time. There is nothing in this case.
Yes, my lord, some time may be given.
Sorry,
for,
sorry. You have nothing in this case. We are not adjourning this matter. We have heard you. You have got anything more to?
At least, my lord, may not be treated as part heard.
We are not treating as part heard. We are disposing of this matter today itself in the court.
It is my predicament, my lord. For my predicament.
You have done,
my lord,
we are giving you all the opportunity. 2010 matters pending till 2026. First so-called notice of 2010.
Some personal predicaments, my lord, on my part. For that, my lord, at least, my lord, 24 hours, my lord, tomorrow. Matter may be treated as part heard, my lord.
Sorry. Normal cases we grant, not this case.
Otherwise, my lord, at least 1 hour, my lord, or half an hour, my lord. I'm not.
You take time till 4 o'clock. We are hearing you. And what is there to be heard? We have read, gone by the judgment. We are asking one question. Forget about everything. Show us one document which can link your title to the land, your right to the land, your claim to the land. One document. There's no document.
My
You
lord,
cannot take up the issue of demarcation, Kamekhali and all this. Show us one document. You have an order in your favor.
my lord, I'm in possession of that plot of land since 1992.
On what basis? What basis? What basis? Tell us the basis. You purchased the land, you got as a gift.
My lord, that is why, my lord, possibly, my lord, I'm not sure, my lord, the government, my lord, in the revenue department, they have allotted some plot of land.
What's the allotment order?
That is why, my lord, some time would be
Sorry,
required,
sorry,
my lord.
sorry.
At least on
16 years is a long enough time, Mr. Fukan. Please do not embarrass this court with this kind of a request. 16 years you have taken to reply to a show cause from 2010. We're in 2026.
my lord, for my personal predicament, my lord,
No, we hearing you. We are
my
giving
lord,
you enough
I'll
time.
have to then, my lord, at least 24 hours, my lord.
Sorry, we have declined that prayer. Please do not make it again. You take your time till 4 o'clock, you argue. We have heard you. If there is anything else,
Then, my
gone
lord,
through the judgment.
at 4 o'clock, my lord. At 4 o'clock.
No, we are not adjourning the matter. We will continue to hear you till 4 o'clock or till 4:30 if you want.
Then I'm extremely sorry, my lord, I will have to recuse since, my lord,
It's up to you.
personally, my lord.
It's up to you.
So since, my lord, for my fault, my lord, the college will suffer, my lord. It's an eviction case, my lord. That is why. Some,
Yes, madam. If he doesn't want to argue, please argue.
Judgment also clearly it is.
We have seen the judgment.
Yes.
Now we are somehow very disturbed with this fact that this kind of litigation which goes on from 2010, there has been litigation. Last litigation had asked you to file an appeal. You had filed an appeal. Appeal has been dismissed. If you want to make out a case that the appellate judgment is bad in law. We agree with you. There is nothing.
my personal problem, my lord. That is why, my lord. My lord.
What personal problem, Mr. Fukan? Was any request made in the morning?
No, my lord, my personal problem.
Was any
my lord,
request made in the morning?
Suddenly cropped up, my lord. That is why, my lord.
Sorry. We have heard you.
My
You have
lord,
done your job.
my lord,
Yes.
my lord,
We have heard you.
after, my lord, my learned friend, my lord, submits, my lord, I will submit my
You can rejoin if you want. But we have heard you. Yes, madam.
Yes. Project, the paragraph 9 he did not pay. Page 93.
You appear for the railways.
Paragraph 9.
Railways. Here for the, okay. Paragraph 9.
my lord,
Judgment.
may I, my lord, point out one thing, my lord. In earlier order, my lord, dated 18/11/2020, my lord,
Page?
the earlier order, my lord, of
Page,
this honorable court, my lord, state government will have to file the affidavit, my lord, regarding this case, my lord.
Why?
My lord, as per order,
We are on certiorari jurisdiction. We are examining an order. If they want to file, they can file. They, if you did not file, will not be restrained by such an order for adjudicating a writ petition which was filed in the year 2019, in 2026. We made it very clear. Old cases, no adjournment. Yes, madam.
Page 93, Lordship, of the Honorable District Judge judgment.
Yes.
It clearly stated that the line further the contention of the appellant that the respondent did not furnish the documents regarding the land though the appellant filed several petitions under the RTI Act, etc., seeking the documents. The same does not make any sense. It is the appellant who should have proved how he came into possession of the land from which he has been running the West Gauhati Commerce College. It is not his case that he has purchased the land. From
We have read this. We have read this. Therefore, we have put the questions to Mr. Fukan. We have read the order.
Firstly, he said that appellant is admittedly a land grabber. So the appellant has got no legal right or title interest in the suit land. He is an encroacher of the railroad land. It has been decided by the Honorable District Judge. And he has gone through all the eviction case, record of the eviction case, everything, Lordship. After that, he has passed the order. They could not take any grounds, Lordship, in their writ petition. They could not challenge the order of the Honorable District Judge. Also, they are running the college, Lordship, for their own benefit, Lordship, not for any government or for any something for benefit of the local people or some person. Lordship. Not doing any charity, Lordship. But they are doing for their own benefit, they are running the college. I have just sit also in my affidavit also.
Page?
Page 12.
You filed affidavit when?
21 also.
Page?
17, 11, 21. Page 12, Lordship.
No. Running page of your affidavit.
That time there was no running.
Okay, we'll have.
In my affidavit.
Okay, your affidavit is there. I found it.
Person number 1 and 2, Lordship.
Just a minute.
One, two, three.
Paragraph?
Lordship. Annexure 1.
Annexure 1, page?
Page 12. Paragraph 4, Lordship, in my in opposition, I have.
Okay, this is the chita.
Sita, Lordship. It's clearly stated that all 76 bigas, 4 kota, 106, 11 lesser. All these lanes are railway, Lordship.
What is the area, madam?
Sarkar, it is format 756 bigha, 4 kota, 11 lesa, whole area lordship is Moja Ram Sarani, Borpandu, Kumarpara. Number 1.
Doug number?
In my paragraph, I have stated that.
In which paragraph?
4, paragraph 4. That the statement, contravention made by the category is denied is more humbly stated, submitted before this honorable court that the said land is a railway land and railways has never relinquished the land nor permitted the petitioner or anybody else to occupy the land. The land under Dag number 1, village Gorpantu Kumapura Moja, Ramsoroni, now Jalupari, district Kamru, belongs to the railways. The petitioner enforces over the railway land, the length of the occupation and person has no relevance while determining the issue of unauthorized occupation. That is, as the petitioner, no title over the state officer has served upon the notices upon the petitioner. Showing the unauthorized encroachment land. Further, Dag number mentioned in the Sita surveyed village dated 2010-2009 shown in the cadastral map certified by Senior Assistant Settlement Officer Gauhati, which is clearly shown as railway land. Moreover, they have not submitted a reply to our affidavit in opposition. They have not. But that picture is cadastral map. Everything is there, not so. These are all railway land. Page 14 also the map has shown
1-4.
1-4 and it's a 3.
What is 14?
Page 14 also.
What is it?
The railway map logic. All these land belongs to railway logic. Trademark.
Mr. Pendick?
This the matter is the one that related to the railway department, so the state government cannot do anything. Even then, lordship, 2015, lordship. 2018, lordship, 15 SSC.
2018.
15 SSC.
2018.
Lordships. 15 SSC. Page lordship 356.
What is there?
Paragraph number 15 is going to state that, my lord, that any order passed by the district civil judge, lordship, they have to file under Article 227.
227. We have considered that aspect, but we may not be too technical. Prejurisdiction may still lie if he makes out a case of irrationality, illegality on the face of it, or principles of natural justice.
When then, my lord, they know that, my lord, it is a railway land, my lord, they can approach the state government earlier, lordships, or my lord, taking, my lord, any government land for establishment of this that college.
Okay.
That has not been done. Nowhere in the petition where it is mentioning. From that time, ought to have the government can, my lord, consider their, my lord.
Okay. Yes, anything?
Nothing, my lord.
Yes, sir.
My lord, my personal difficulty may be recorded, my lord.
Yes, we'll record your difficulty. The instant petition under Article 226 of the Constitution of India has been filed challenging an order dated 23/2019 passed by the learned District Judge Kamrup M in Miss 10/2017. Full stop. The said appeal was instituted under Section 9 of the Public Premises within bracket eviction of unauthorized occupations, bracket close Act 1971 by the present petitioner, which was dismissed. Para. As per the facts projected, an eviction proceeding was initiated by the respondent railways in the year 2010, which was followed by a number of litigations, including those in the High Court. Full stop. Thereafter, a show cause notice was issued on 22/11/2017, culminating in the order dated 15/2/2018 directing eviction of the petitioner from the land of the railways. Full stop. The said order was put to challenge in the appeal indicated above, which has been dismissed by the impugned order dated 23/2019. Full stop para. I have heard Sri P.J. Fukan, learned counsel for the petitioner. I have also heard Ms. R. Bora, learned standing counsel, Railways, Ms. A. Gayan, learned CGC, Sri G. Handik, learned State Council. You are also the revenue, and Ms. Ann Bodler, learned standing counsel, Revenue Department. Full stop. Para. At the outset, comma, Sri Handik, this court would like to record the submission of Sri Handik, the learned State Council, who has raised a preliminary objection that orders passed in an appeal under Section 9 of the Act by the learned district judge can be challenged only by an application under Article 227 of the Constitution of India. Full stop. While the aforesaid submission would definitely warrant merit, this court is of the opinion that instead of going into the aforesaid technicality, the maintainability, the aspect of maintainability of this petition would not be gone into, as the writ jurisdiction has been tried to be invoked by the petitioner. Full stop. Para. Sri Fukan, the learned counsel for the petitioner, has submitted that the learned district judge, while deciding the appeal, did not take into consideration the relevant factors and had proceeded on the basis of surmises and conjectures. Full stop. He has submitted that certain documents were applied under the RTI, which would have relevancy in the adjudication process, and that aspect has not been appreciated by the learned district judge. Full stop. He has also submitted that if the learned district judge had gone into the extent of questioning the right of the petitioner over the land in question, such question would also be applicable so far as the railways is concerned. Full stop. Full stop. The learned counsel has, however, submitted that he was not fully equipped with all the instructions today. Full stop. Para. Per contra, Ms. Bora, the learned standing counsel railways, has submitted that the present attempt is nothing but a move to drag the proceedings which was initiated in the year 2010 itself. Full stop. By referring to the affidavit in opposition filed on 22/11/2021, the learned standing counsel has drawn the attention of this court to the documents enclosed therewith, which includes the cadastral map, which includes the chita and the map indicating the land in question which belongs to the railways. Full stop. She has also submitted that in the impugned judgment dated 23/2019, the learned district judge has taken into consideration all the relevant aspects and has also dealt with the plea of the petitioners that certain documents were sought for under the RTI. Full stop. She has submitted that the learned court has come to a conclusion that seeking documents under the RTI to show the ownership will not make any sense, as it was the duty of the petitioner appellant to place all the documents and prove how he came into the possession of the land and running the college. Full stop. She has also drawn the attention of this court to various other documents, including FIRs lodged from time to time, whereby the petitioner and his agents had tried to obstruct railway works. And one such FIR is dated 31/10/2006. Para 3. The learned Standing Council accordingly submits that the instant writ petition is without any merits and is liable to be dismissed. Para 3. No, my handing in this connection. In this connection, he has referred to the decision of the Honorable Supreme Court reported in 2018, 15 SCC 356. What is the name?
My lord, LIC versus Nandini Shah. Nandini CS Shah.
Nandini Shah. It উপরেতে থাকিব, হ্যাঁ? এটা preliminary. Both Ms. Gayan, the learned CGC, and Ms. Bordola, the learned Standing Council Revenue, have supported the stand of the learned council for the railways and has submitted that the impugned order dated 23/2019 is justified and does not require any interference. Full stop. Para. The rival submissions have been duly considered. Full stop. As mentioned above, this court has not gone into the technicalities regarding the maintainability of the writ petition, which was raised by Sri Handik, and has dealt and has considered the rival submissions on its merits. Full stop. Though Sri Fukan, the learned counsel, had expressed certain predicaments, this court would also record that, considering that the writ petition, that the eviction process was initiated in the year 2010, and long 16 years have passed, and the writ petition is itself pending since the year 2019, this court is not inclined to grant any further adjournment. Para. At the outset, this court would like to remind itself that in exercise of its certiorari jurisdiction, the contours are limited, which has been well settled by by a catena of judgments of the Honorable Supreme Court. Full stop. In this connection, it would be beneficial to refer to the judgment of so-and-so, wherein the following guidelines have been laid down, particularly for exercising certiorari jurisdiction. Full stop. Para. The challenge, as indicated above, is against the judgment dated 23/2019 passed by the learned district judge in an appeal filed under Section 9 of the Act. Full stop. The said appeal was preferred against a notice dated 15/2/2018 for eviction. Full stop. The records would clearly show that the initial show cause notice was issued on 15/3/2010 in eviction case number EO/MLG/1041/2010. Full stop. The learned district judge has also recorded that there has been protracted litigations which has dragged the proceeding, and finally vide an order passed by the High Court, comma, the appeal was directed to be preferred, which was accordingly done. Full stop. The learned judge has recorded the grounds of appeal and has come to a finding that the petitioner appellant could not demonstrate any materials as to how he came into possession of the land from which he is running the college. Full stop. This court is of the opinion that the conclusion arrived by the learned district judge, wherein he has rejected the plea of seeking documents under the RTI application, RTI Act, is in the right direction, inasmuch as if the petitioner claims to be the owner or possessor of the land, comma, he is under a bounden duty to show, to demonstrate, to prove the same by documents, and such documents would have to be in his possession and cannot be the subject matter of any RTI application. Full stop. On the other hand, comma, the respondent railways, which had contested the case, has also enclosed in the affidavit of opposition filed on 22/11/2021 documents, including the chita, which would prima facie show that the land belongs to the railway. Full stop. There has been an argument has been sought to be advanced that the demarcation process is also not complete. Full stop. In the opinion of this court, such argument cannot be countenanced in view of the fact that the appeal, which was filed under Section 9 of the Act, was in pursuance to a direction of this court, and the appeal has been decided by taking into consideration all the relevant aspect which is required to be done. Full stop. The objective of the Act of 1971 is to provide a speedy machinery for eviction of unauthorized occupants of public premises. Full stop. In the instant case, comma, the eviction notice was initially issued on 15/3/2010, and the process is yet to come to an end, inasmuch as while this writ petition was moved, an interim order was passed. Full stop. In view of the aforesaid discussion and facts and circumstances, comma, this court is of the opinion that no case for interference is made out qua the impugned order dated 23/2019, passed in Miss Case 10 of 2017, passed by the learned district judge Kamrup M. Full stop. Writ petition accordingly stands dismissed. Interim order passed earlier stands vacated.
Most obliged.
records sent back.
Article 21.
Lordship,
Yes,
initially,
Mr. Viswas?
But the matter relates to the issuing new license for the trade.
Yes, he was just trying to make some submission. Your junior associate has taken time. Said the husband has passed away
Has passed away.
and she applied for a renewal of the license.
We have renewed in the name of husband because the earlier agreement has not renewed by the tenant. Tenant has demolished on the direction of the municipality.
He has some dispute with the tenant, with the landlord,
Otherwise, they have filed a civil suit with the tenant.
with the landlord.
Landlord. And also police case against landlord. It was demolished under the direction of the executive engineer PWD because it is very hazardous condition. And all the
Mr.
tenants have
Mukherjee,
agreed.
what can be done under this circumstance?
Lordship, in fact, when this matter was taken up in the motion stage, there was a
Yes,
direction, not a direction, there was an observance that whether a trade license can be transferred. Under such circumstances, I was given the permission to apply in my own name. That was done, Your Lordship. I have annexed. I have paid that license fees and I have applied. However,
Mr. Mukherjee, is there any provision in a matter of this situation, like those of electricity? There is a provision that if there is a landlord and tenant dispute and the electricity is disconnected by the landlord, then the tenant in such a situation can get a temporary connection
Lordship.
without even the consent of the landlord. Is there any such provision so far as a trade license is concerned? Now, admittedly, you are running your business from a rented premises. You are in dispute with the landlord.
Lordship.
Landlord will never give you a consent to run the business.
NOC will not.
So under these circumstances, how can you bind Mr. Biswas to issue a trade license when there is a requirement of a no objection certificate?
Lordship, there is a requirement for no objection certificate.
Now, to do away with the requirement of no objection certificate, is there any
There is no
alternative?
There is no specific rule in that regard. I could
So
not
if
find
there is
any.
no rules, if there is no prescription,
So
how
we
can we give
we have
issue a mandamus?
Lordship, we have filed an application and we have stated, we have narrated.
No, we can direct for consideration, but that may not be you may not get any fruits out of it.
But there is a provision that we have to produce the tenancy agreement or land authorized of the authority of the land, owner of the land. Otherwise, license cannot be granted.
No, Mr. Biswas, that is what we are.
Yes, exactly.
Now, if there is a dispute, there will be no tenancy agreement, there will be no
Nothing.
consent. So,
Well, but we undertake that we will give our land. We will give our accommodation after the completion of this matter, that is renovation. There is no dispute, we will give her. We have agreed the other tenant also. We have demolished because there is a direction from the PWD. It is in a dangerous position, front side of the building.
Lordship, my
Now that,
learned friend is submitting.
no.
We have
Not your learned friend, learned senior friend.
my learned senior friend is submitting on behalf of the municipality.
Yes, no, municipality, why did you demolish the house?
What was the direction?
This houses belong to you or the landlord?
How it belong to the other person. But he
Landlord.
has not been made a party.
Oh, landlord is not a party.
Landlord is not a
Why?
Say why they.
Lordship, here the municipal board is saying that.
Why haven't you made the landlord a party? To be a necessary party.
Lordship,
Should have been.
Lordship, in fact, there is a civil dispute. There's a suit pending already. Your Lordship.
Understood.
And in the affidavit, Your
You
Lordship,
should have made a landlord a party.
and presently the trade license is renewed in the name of the deceased husband, Your Lordship. It
We
is
have
not a
helped him
case.
so that she can run the business, even illegally.
So there is no impediment to issue it in the name of the petitioner, not the deceased husband. After the death, it has been.
What about considering her application afresh?
Yes.
You can consider.
If you directly I'll do, I have got no objection. But so far our condition is that there must be an agreement. That is precondition.
You do not have any other space.
No other space.
That we cannot direct. We would have directed if the landlord was before us. It's not a question of consent, but by hearing. Now, without even hearing, how can we burden somebody?
No, I do not know why my friend is conflicting, because she have to do the business for her survival. I think a good relation will help her
and let the landlord be make party. And
Mr.
make it-
Mukherjee, make the landlord a party. We'll try to sort out the matter, okay? Heard Sri B.J. Mukherjee, learned counsel for the petitioner. Also heard Sri S.C. Biswas, learned counsel for respondents 3 and 4. 3 and 4.
Yes, ma'am.
Full stop. After hearing the matter at some length, it transpires that there is a dispute of the petitioner with her landlord, which is the root of the present lease, LIS Becker. However, the landlord has not been made a party respondent. First of para, Sri Mukherjee, the learned counsel, prays for and is granted 2 weeks' time to file appropriate application for implement of party respondents. Para. In view of the above, matter is adjourned to be listed along with the I that may be filed.
Item 27.
Lordship, you may adjourn the matter for the day as Mr. Sigdar is on legs, and this matter needs to be heard at length, Lordship.
What is the matter?
Eviction matter, Lordship. Eviction matter, Your Lordship.
Stay is operating, Lordship, since 2020.
Okay, today he has come.
Oh, he's all.
Yes, Mr. Sigdar, what is this?
My lord, here in this case, my lord, the petitioner, since the days of his father, is residing on a plot of land since 1975. Several eviction notice has been issued, and that were also challenged. The first notice, my lord, was issued in the year 1997. Lordship may find page 35, my lord. This is the first notice.
Thereafter,
my lord, then another notice.
now what are you challenging?
My lord, now we are challenging. Lordship, I may brief in fact, my lord. Then that notice was challenged in a civil suit, DS 6, 1998. There has been some interim order at page 44. Then, my lord, during the stay of that case, another notice has been issued in the year 2011. And following to that, another proceeding was, eviction proceeding was taken up in the year 2012. That is Annexure 10, page 52. Again, that notice was challenged by filing writ petition. Annexure 11, page 53. This small court has disposed of that writ petition with a direction to file an appeal. Paragraph 8. My lord, then appeal was filed. Miss Appeal, it was registered as Miss Appeal, Miss Civil Appeal number 4/2012, Annexure 12. My lord, the order, the consequential order, Lordship will find at page 61, paragraph 16. There was a direction to the input notice was set aside, and there was a direction for inquiry.
Fresh inquiry.
Was
the fresh inquiry?
Fresh inquiry was they are claiming that it has been done, but without intimating, about the individual
Fresh inquiry was done or not?
Done, Lordship.
Was the petitioner taken into confidence? Was it done in his presence?
He was not present at that time, because Lordship, this inquiry was done not only on his plot only. It was done and to the entire plot, and all revenue.
No, Mr. Lockwood, that is okay, but we are adjudicating the claim made by one of the petitioners. There was an order to make a fresh inquiry. If you had made extended the scope of inquiry for other lands, we do not have any objection. The problem would be, while this fresh inquiry has been done pursuant to an order of this court in a proceeding instituted by him, he has to be taken into confidence. In his presence, at least you have to do.
Direction was to Lordship for a joint inspection, Lordship. A joint inspection, so joint inspection was done. It was with the
joint inspection means, let us see the order. Disposal of 6/11/2017 order. 6/11/2017 order.
56, Lordship. Page 56.
56.
And operative.
Let us see the operative for 62.
61.
61.
Okay, so 56, page 61 is the operative portion.
Yeah,
last-
61. Was not duly authorized person to. See, come to the paragraph 16. In the result, appeal is allowed partly. Impugned order dated so-and-so and order dated so-and-so are set aside. Case of the eviction, case number so-and-so, is remanded for holding enquiry afresh by the state officer. Further, the state officer directed to complete enquiry within 2 months from the date of the receipt of the judgment of so-and-so. See, this judgment was rendered in an appeal under section 9, preferred by whom?
Preferred by the
By the petitioner. So it was incumbent upon you that while you make the fresh inquiry, it has to be some documents or whatever has to be sought for from him.
After that, Lordship, after joining inspection, that notice, section 4 notice has been served upon them, Lordship. No, but they did not participate in the hearing procedure.
Fresh inquiry.
Lordship. They
Where,
did not,
where,
they did
where,
not, they
where,
did not participate.
where have you stated?
This is Lordship. In my affidavit, Lordship, page.
Okay, we'll, today, we have to correct the orders, not today. Some other day, Tuesday next.
But we have a right to appeal against the fresh inquiry and the fresh order, my eviction notice, my lord. That we have the right to appeal, my lord, under section 9, my lord.
9, yes. Yes, that part is also there.
My lord.
Because the state officer has to pass a final order for eviction and which is appealable under section 9. But he has come to the court before that because he alleges that in the fresh inquiry, he was not given any opportunity. Okay. Wait to record you, huh? Paucity of time will not permit this matter to be taken up today. Para, on request, list on Tuesday. Okay. Rest of the matters, courtmaster will give dates. Mr. Chakraborty, which matter?
Leave of legislation.
24. 24 are all connected.
Yes, madam. It's a small issue involvement.
Why is it for orders?
Implement, madam.
Implement. We can implement it.
Yes.
Only one thing, he has paid for infringement and striking of both. Regarding infringement, it can be done, but striking of will be difficult.
Striking off of whom?
The original.
Assam Textile Corporation. That has been closed down, my lord.
It's an.
And
You have appear for whom?
I'm waiting for the private respondent, Lordship. 17 respondents are workmen.
I am for AIDC. We want to get implemented in this matter.
Implement.
Small
Why do you strike off?
That part, Lordship.
Strike off, madam, that
Entity is not there.
not there. Its name has been struck off from the ROC also, madam. That is why.
That Lordship.
Now let it remain. How does it? Will not be prejudiced.
Lordship, because
You would be prejudiced if in the adjudication process if a necessary party is not there.
Lordship.
Now you have made him a party. He is not there now on the records. It will not affect your rights. We can allow the implement.
Yes.
Implement, Lordship.
Okay. It will pass code.
Madam.
Heard 3 as does learned counsel for the applicant
Applicant.
who by means of this application has paid for 35 has paid for implement of the following party as respondent number.
No, my lord.
Petitioner, Lordship.
As a petitioner. Because originally, madam, it was a management worker dispute, madam, between
Award,
Assam
Lordship.
Textile Corporation and the workers, madam.
What you want to do?
Before the labor
To file
tribunal.
an implement.
Lordship.
You have to file an
Yes, Lordship,
intervening
Lord,
application.
will kindly see the last order, madam, last page, madam, 34. Page
You have to
number
file intervening.
Intervene, Lordship.
You can intervene. You can can be transposed into the position or status of the petitioner, but you cannot be petitioner.
Award, Lordship. Award is in favor of STC, Lordship.
To think over. We can also treat this as an application
Yes.
for intervening
Yes,
and give you the status of the petitioner. You can still argue.
yes.
Think over. Okay.
Lordship may pass order, madam.
No, you assist us.
My-
There
my-
will be some judgments where application of this nature has been treated to be applications for intervening.
Madam.
We thought they want to add some respondents.
No, madam. Date be fixed, madam. Monday, Tuesday.
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 Come prepared, okay.
Highly.
Itu একো নেলিখিবা paucity of time কৰিব rest on Tuesday.
Lordship, item number 29, my lord. In the mentioning the rate petition with which it was supposed to tag, my lord, wrongly mentioned, for which the matter has been posted. 29, my lord.
Supply.
Supply, my lord.
You had made a mention something, no?
My lord.
What is it?
My lord, or the rate petition with which is supposed to posted, my lord, 5896 of 2025, my lord.
Okay. You want to clarify, okay. Heard Sri J. Laskar, Learned Counsel for the petitioner, also perused. Also perused the office note dated 21/4/2026, full stop. Sri Laskar, the Learned Counsel has clarified that the similar matter is WPC 5896 of 2025
My lord.
and not WPC 5896 of 2020 as recorded in the order dated 13/3/2026. Full stop. Para, it is accordingly clarified that this case is to be listed along with WPC 5896 of 2025. Returnable date is already over.
Over.
In 23. When is the next date in that
My lord,
case?
in that case, after 3 weeks, my lord. Today it was before court number 22, my lord. It was adjourned and it was posted after.
Don't say the date, huh?
Obliged.
Okay.